Yeah. Please don't record. I think the only person that can record will be a court reporter or something like that. Anyway, what we got here? Civil case 2022 CV 26-107-2720. Republican Party Reese Boyd versus Robert Slagle, Barbara Treacy, and Angela King. It is a claim and delivery action representing the Horry County Republican Party. Is Mr. Boyd or who?
Yes.
Your Honor, I think it's both of us. I think that's kind of part of the division on this asset or on this case.
Oh, okay.
We have filed a motion to dismiss that we'd like to appreciate the court hearing.
Okay. So we got motions before the court before we start, right?
Yes, Your Honor.
Well, Your Honor, that motion wasn't filed. I didn't get a copy of it until we arrived at the courthouse. So
all right.
I would object to the timeliness of that motion. We really haven't had a chance to review the memorandum. Bert's got a lengthy memorandum here that he's filed, and as I said, I didn't receive a copy of this, Your Honor. He indicated he emailed it to my office this morning, but I didn't receive a copy of it until I arrived at the courthouse just now.
Gotcha.
Your Honor, the first and foremost is standing and jurisdiction. So I'm sure Mr. Boyd's familiar with those. But we have no objection if he needs a few minutes. These motions are routinely filed the day of. This is nothing. There's nothing here that's a surprise. We talked about it in the last hearing.
Well, you've got a jurisdictional motion, right?
Yes, sir, and a standing issue. Yes, sir.
You want to look over that first, Reese? Or I understand, yes, you did just get it, but it looks like are you claiming that the summary court doesn't have jurisdiction because of the amount?
The amount, Your Honor, that the affidavit does not comply with the statutes, therefore it is not before the court properly, that these are not the parties of interest which are required to bring it before the court, that the Horry County Republican Party is actually not a recognized entity. The South Carolina GOP is, and this is just a subdivision. It's the equivalent of a Walmart manager trying to bring a lawsuit on behalf of Walmart. That's the equivalent. Take all the politics out of all this. It's just an organization is what it is. And it has to be brought by people that have an interest in the outcome independent. And there certainly should not be officers of a subdivision that would have an individual interest in what amounts to a state legitimized organization.
So you hadn't had a chance to read it at all whatsoever?
I just received it about 5 minutes ago, Your Honor.
Well,
but I'm happy to argue.
Well, you tell me.
I'm
want to look over.
If Your Honor wants to proceed, I'm happy to proceed.
Well, jurisdictionally, you understand that if the other side's claiming that we don't have jurisdiction because of the amount, and I don't know if there's a counterclaim or whatever else, that we make that rule based on that. Go ahead.
Your Honor, perhaps we can perhaps I can briefly present the case to you and respond to the jurisdictional amount question, and we can go from there.
Mr. Von Harmon, any problem with that?
No, sir, Your Honor.
Go ahead.
Thank you, Your Honor. May it please the court.
Certainly.
Your Honor, this is a claim and delivery action, and it is brought on behalf of the Horry County Republican Party, and I'm just going to briefly try to describe to you in a fairly concise nutshell how we got here. That may be easier said than done, but the property at issue, Your Honor, basically is the personal property that was in the possession of the party at the time of a special election that took place on October 11. And the people, the individuals, myself included, who were elected at that special election are simply asking for this court to issue an order for any personal property of the party to be delivered to the new officers. And I think that's entirely appropriate for a claim and delivery, and it is by necessity that we brought this action, as I think the court will see. And so I think the standing questions will resolve themselves, but we'll address those as they arise, Your Honor. This matter goes back further, but we'll start with September 12, 2022, Your Honor. That was a a meeting of the Horry County Republican Party, at which time, and this is in our complaint, this is page 1 of 3 of the narrative, if Your Honor wants to follow along, where the former officers of the party resigned. They resigned all at one time, and that resignation was made at a public meeting of the party on September 12, 2022. Those resignation letters, which they subsequently submitted to the state party, are also included in our complaint, Your Honor. You'll see those as Exhibit A to the complaint. And then later, Your Honor, on September 12, we note that also that the vice chairman of the party, Jeremy Halpin, had previously resigned, and so we had a circumstance where there were no officers, or there were going to be no officers, based on these resignations of the officers, Your Honor. And then, so after they notified the state party, hey, we've all resigned, on September 13, excuse me, Your Honor, on September 13, the day following, they did notify the state party that they had resigned. On September 15, the state party, in an email from Hope Walker, who was the executive director of the state Republican Party, acknowledged the resignations. And that's Exhibit B to the complaint, Your Honor. So a couple of days later, the state party said, okay, we realized you resigned. Then there is another letter in our complaint, Your Honor. It's Exhibit C, where the former chairman, Mr. Slagle, a defendant in this case, again writes the state party, telling the state party what needs to happen. There needs to be a special election according to our rules. That is Exhibit C to the complaint, Your Honor. Then later in the month, September 26th, and we do have this rule, Your Honor, here with the Republican Party in Horry County, if all of the officers resign, so that there's no officer to take control of the party, then we have what's called a provisional chairman. And that provisional chairman is Michael Connett. Michael Connett is one of the plaintiffs, Your Honor. He could not be with us today. He is not well, but he is one of the plaintiffs in this matter. So Mr. Connett had already been chosen, elected as the provisional chairman in the event that all the officers were to resign or to be, for some reason, unable to serve, Your Honor. That's kind of a fail-safe. And so Drew McKissick wrote a letter to Michael Connett as provisional chairman. Again, Mr. McKissick is the chairman of the state party. He writes a letter to Mr. Connett saying, Mr. Connett, you're the provisional chairman. Hold a meeting and elect new officers. And that is Exhibit D to our complaint, Your Honor. And then later, Your Honor, as we allege, or as we discuss in the complaint, Mr. Slagle on September 26 subsequently communicated to the state party attempting to rescind his resignation. But on October 3rd, McKissick sent Mr. Connett, the provisional chairman, a letter noting that elections to elect new officers should be held as quickly as possible, and that there was no provision for unresigning, so that Mr. Connett should proceed with a meeting, and that there should be a new election, new officers should be elected. That meeting took place on October 11, Your Honor, and the officers who are plaintiffs here today, myself, Mr. Connett, and Mr. Rob Visconti, who is the state or the vice chairman of the party, were elected at that special meeting. The next day, Mr. McKissick, chairman of the state party, sent a letter to myself congratulating us on being elected. That letter is Exhibit F to our complaint, Your Honor. We then subsequently, where this really came to bear, we sent a letter to the former officers of the party, that's Exhibit G to our complaint, Your Honor, requesting that the property of the party be turned over to the new officers. Subsequently, Your Honor, Mr. McKissick, chairman of the state party, also sent a letter to the defendant Slagle and the defendant Tracy, requesting that all funds, personal property, passwords, social media platforms, etc., belonging to the Republican Party be returned to the duly elected officers of the party. And that letter is also attached to our complaint, Your Honor. That's Exhibit H to the complaint. Notwithstanding all of those communications, Your Honor, and all of those requests, the new officers, Your Honor, thereafter refused to relinquish any of the property in their possession. I think it's instructive, Your Honor, that counsel for the defendants is now going to argue, based the way he set up his motion, that the South Carolina GOP is one entity. Because that's exactly our argument, Your Honor. The SCGOP is one entity, and you, as the local chairman of the Republican Party, do not get to go your own way and declare yourself an independent republic, even though we have that habit, Your Honor, in Horry County. It's a long-standing tradition. I admire it, but unfortunately, that's not the way the rules of the party work, and that's not the way the state Republican Party works. It's instructive, Your Honor. I'll just point out one thing that's also attached to our complaint. During October, there were a series of communications leading up to the November elections. This is Exhibit I to our complaint. And in that complaint, Your Honor, or in that period of time, there were some discussions between the local election authority, Sandy Martin and her staff over at the Election Commission. There were discussions over who were going to be poll watchers for the local party during the November elections. Mr. Slagle exchanged several communications with Ms. Martin. I had communications with Ms. Martin. And in that communication, Ms. Martin obviously had some confusion, and she wrote to the party, the Election Commission in Columbia, the State Election Commission, Your Honor, which is charged under Title VII with administering elections and political parties and the requirements and the approvals of political parties. That's all under the jurisdiction of the State Election Commission per Title VII, Your Honor. And Mr. Knapp, the chairman of the State Election Commission, Howie Knapp, wrote back to Ms. Martin. If I may approach, Your Honor, I actually have a copy. I'll share it with you.
Howard Knapp.
So, Your Honor, Mr. Knapp wrote back to Ms. Martin, Sandy Martin, at the County Election Commission and said, Sandy, if I were you, I would not respond to any more of Mr. Slagle's communications. You are in the middle of an election, and Mr. Slagle's persistent communications border on harassment. And then this is the significant part, Your Honor. I want to reiterate that there is only one recognized Republican Party in the state of South Carolina. While county party organizations may refer to themselves as the, whatever county we're talking about, the Horry County Republican Party or the Saluda County Republican Party, et cetera, they are all subdivisions of the South Carolina Republican Party, which is exactly what opposing counsel just said, Your Honor. The South Carolina Republican Party, through its executive director, has stated that the chairman of the Horry County Republican Party is Reese Boyd, not Roger Slagle. If Mr. Slagle wants to continue to represent himself as an officer of a party where he is not, that is between him and the party. Again, Your Honor, this is an email from Howard Knapp, who is the chairman of the South Carolina State Election Commission. If Mr. Slagle wants to continue to represent himself as an officer of the party when he is not, that's between him and the party, but it is not a concern for you or any other elected official. So, Your Honor, I think where we are is clear. There has to be someone who has a say. And I think it's also clear that this court does not want to entangle itself in the internal operations of the Republican Party. I think that is also clear. But I think what we have here is a case where the state Republican Party, through its chairman and through its executive director, have spoken. They have specified who the officers of the Republican Party are. And they have specified that it is the plaintiffs in this case. And those plaintiffs, I would argue, are entitled to a return of any personal property belonging to the Republican Party. They may call it the Horry County Republican Party, but it doesn't really belong to the Horry County Republican Party by their own admission, Your Honor. It is Republican Party property, and it should promptly be returned to the officers who are designated and currently entrusted by the Republican Party to run party affairs in Horry County. I don't see how you can look at it any other way, Your Honor. And as to Mr. Von Herman's argument that the property exceeds the jurisdictional limit, Your Honor, there is a bank account that's involved with several thousand, approximately 30 to 35,000 in it last time we had information. It clearly exceeds the jurisdictional limit, but we did not ask for that, Your Honor, and we have not asked for that. But what we have asked for is various tables and chairs that were stored in a storage facility that was maintained by the Republican Party after the meeting in October where the new officers were elected. They moved that personal property. So we don't know exactly where it's located today, Your Honor, but I think it's entirely within the jurisdiction of this court to issue an order directing that all personal property belonging to the party be returned to those officers who have been duly elected and are currently designated by the state party as the officers of the Republican Party as the officers of the Republican Party in Horry County. And so the properties that we've requested include a computer printer, some tables, some chairs. Significantly, Your Honor, I think the financial records of the party, we're talking about paper, but the financial records are a discernible, tacit, personal property item. They clearly have no monetary value per se, but they impede the ability of the officers, whoever they may be, to run the affairs of the party without that information, without those records. So when we ask for a computer printer, a few tables and a few chairs, and some financial records, we're clearly not asking for anything, Your Honor, that exceeds the jurisdictional limits of this court. So I think that argument fails. And I think the standing argument fails, Your Honor, as follows. The state party actually is here today. They're represented by counsel. Ms. Hannah represents the state party, and she's here with us today. So they're clearly concerned about this matter, but we're also entitled as officers in the organization to bring an action in our personal capacities and also in our capacities as officers of this organization. I don't believe there's any requirement that the plaintiff has to be the chairman or the executive director of the state party. And lastly, Your Honor, I think I will share one final item with you that is not in our complaint. Your Honor, bear with me 1 second. This is not the only county, Your Honor, unfortunately, where these kinds of disputes have arisen. There was a recent dispute that arose in Oconee County.
Your Honor, I'm going to have to object here. What happened in Oconee County, they don't have the record, we don't have the facts, we've got an order, and quite frankly, the order does not address these issues and is not instructive nor binding upon this court and is totally irrelevant to the proceedings today.
Your Honor, Mr. Von Herman has attached this order to his motion.
For that very specific reason is because it was brought up last time when we met, and for the exact reason that it is not binding or in any way. And in fact, quite frankly, a little bit surprising that it was found in any way, because that actually orders to a party or to a person that's not even a party to the action to be able to be entitled to some of the assets.
Your Honor,
It's completely irrelevant.
I'm not suggesting that the order is binding on this court in any way or that this court is obligated to follow it, but it is instructive, in my opinion, in that the language reiterates what we've discussed, which is I don't think it's appropriate or permissible for this court to entangle itself in the internal affairs of the Republican Party. What this court can do is order that personal property be returned to its rightful owner, which is the state party, or the persons that the state party has designated, which is the plaintiffs in this action. And when the court says it is the role of this court to determine whom is entitled to possession of the assets in question, that's the second paragraph on page 1, the order of disposition by the magistrate court in Oconee County. When the magistrate court judge issued this order finding it is the role of this court to determine whom is entitled to possession of the assets in question, it is the court's opinion that the ownership of the property should belong to the officers in good standing of the Oconee County Republican Party. I think that principle of law is something that this court can look to for persuasive guidance in this matter. It's not binding on this court, Your Honor, but I think it's instructive to the line that this court should draw between determining who the rightful parties are to be entitled to possession of personal items versus entangling itself within the internal affairs of the Horry County Republican Party or the state Republican Party, Your Honor. And so that's the case, Your Honor. I think the jurisdictional limits are not a problem. We're not asking for anything of great monetary value. Certainly does not exceed the limits of this court. I think this court does have jurisdiction. I don't think standing is an issue for the reasons I've set forth, and I think other courts have dealt with this issue and dealt with it properly. And it also, that case points to the fact that we're not per se out of bounds here, Your Honor, on a jurisdictional question. Other courses have addressed very similar cases. Other magistrates have addressed very similar cases. So I think this court does have jurisdiction. You have jurisdiction, and we'd ask for an order returning what personal property does belong to the state party to the currently duly elected officers of the party. Thank you.
Gotcha. And Mr. Von Herman.
All right. This whole thing, our argument about jurisdiction and parties can really, first the court is kind of being inadvertently, I really believe, being inadvertently misled where Mr. Boyd says that they're not asking for any money. If he would look at the Exhibit H, written to Mr. Slagle on behalf of the Republican Party, the very first thing they ask for is any funds or monies held in cash or equivalent. He acknowledged that it's over $25,000. That in and of itself is sufficient to take it without the jurisdiction of this court. In addition, Your Honor, what they have failed to mention to the court is there are petitions already filed and have been filed in the Court of Common Pleas, for which likely this court is being asked to initially find that they are the duly elected individuals that are leadership in the Horry GOP. That could certainly conflict with what they've already got a filing in a case ongoing in the Court of Common Pleas, and would put this potentially at odds with a court of a higher jurisdiction which has sole jurisdiction with regards to that. The inquiry is really, when we start talking about duly elected, the election for which Mr. Boyd and all of those individuals that are now claiming to be officers required a 2/3 quorum, and it had to be done by their bylaws. The bylaws have to be followed by the state election laws. The election laws say that they have to abide by any published and any established bylaws. The election from the ECs, that's executive committees, which would elect Mr. Boyd and the other individuals, did not have a quorum present at the time that it was taken. Therefore, the election was not duly elected. They were not duly elected at all, which would result in this not being an action where these individuals are the plaintiffs and have standing to bring it before the court, because they're not elected. So what they're really trying to do, Your Honor, is they're really trying to get this court at odds with an ongoing litigation in the Court of Common Pleas, and asking this court to necessarily find that they were duly elected. And therefore, that's the only way they can maintain their action, is to have this court run the risk of going afoul of an ultimate finding by the Court of Common Pleas. There's a dispute here, no question about it. It needs to be resolved in the court of competent jurisdiction as to the amount of money, to the specificity, for which in their case they have asked for a number of things, including a computer printer. I would point out to the magistrate's guidance that has been provided, where it actually says that to describe in an affidavit a 19-inch color TV is insufficient for a claim of delivery action. Furthermore, Your Honor, it is not just passwords that they're asking for. It is passwords that have anything to do with with any filings or passwords that have any type of relationship to the Horry County GOP. That very well could be interpreted to be their personal email accounts where they have posted things that have relationships or invitations. That's pretty wide open, Your Honor. That is not, and quite frankly, passwords are not personal property, for which a claim and delivery would be. Claim and delivery, Your Honor, when you go through these 9 things, the general test, as it's been set forth and given guidance to the judges, is if I were to order this and I was to send a neutral law enforcement officer to the location for which they reside, could they identify it without any further help? And I submit to you, Your Honor, there is not one of these 9 that they could actually do that on their own. They have not in any way or with any specificity declared that they're within Horry County, and in fact some of them are not. They have hired and retained a lawyer and have delivered documents to another jurisdiction for the purpose of advancing the lawsuit and the petition for pre-suit discovery. They are prepared to do a mutual discovery so they can determine who the duly elected official should be in this case. The only thing that really is different here is they are bringing in the Republican Party. This is across the board. This is any organization. They have to follow their own rules. They have to ask this court in a claim and delivery situation, they have to say that they are the rightful owner and they have the right to possess it, either general or specific, and then it has to be known with some specificity where it is and what it is. I submit to the court that multiple folding chairs, white with padded seats, approximately 70. It doesn't tell us anything. It doesn't even say it's in the county. Multiple meeting tables, approximately 4. It's going to look kind of odd to ask the court to, I'd like to see them draft that order. A computer printer. Any particular computer printer? A corporate records of the Horry County Republican Party. It is not a corporation. They do not maintain corporate records. Even Mr. Boyd has indicated the only corporation is the South Carolina Republican Party, and all of those records will be kept in Columbia. All meeting records, attendance records, mailing lists, and similar records now maintained or previously maintained. So not only they're asking this court to go and ask them to get something, they're asking for my clients to go hunt it down for them and bring it back. That's not the purpose of a claim and delivery. This, Your Honor, is 100% for dog and pony show. It is not to do and not to follow the law of claim and delivery. This was an expedient way to get before a court to get a ruling, which is just typically kind of a rubber stamp situation. Most likely it is a security interest in property. If there's no debate about who the owner is, it's been determined by a court, whether it be this court or a court of common pleas, whether it's done by lending institution or any of a variety of different ways. This is just not a proper method, Your Honor, and that's all we're asking. They're not duly elected because they did not have a quorum present. If the court would inquire of them if they did, that answers one question right there, because if they didn't, and we've got proof they didn't, they were 10 short, then there's no election. They have no right to it because that's within their bylaws. That's within the Horry County and the state bylaws. Just because Drew McKissick, who is not here today, anoints the fact out of his part-time position that he says that he recognized Mr. Boyd, that very may be, but that's not what the court is ultimately supposed to be involved in at this level in a claim and delivery, and that is what they're asking this court to do. Because in order for this court to issue an order to go get these ephemeral items that they don't even have with a degree of specificity nor location, they have to be the duly elected officers. That's all they're trying to get this court to do. What they need to do, Your Honor, is they need to bring the proper action within the Court of Common Pleas, a court within competent jurisdiction, under either an injunction or a summary relief that would specify who it is that it could be for which these folks would be entitled to call witnesses, do discovery, find out exactly everything that went on. You have to remember, Your Honor, there were at least 10 people that were not provided any type of notice to this meeting the day of the election. The more
Your Honor, I'm
instructive
going
thing-
to object to that. I don't know, there's no basis for that.
Object to what I argued? I'm
No, Your
not
Honor,
sure how that
he's
goes.
making
But
there's no basis for stating that people weren't given notice. There's nothing before the court that would provide a basis.
Your Honor, I did not say that I said that we have 10 people that did not receive notice. If they gave notice and they can prove it, fine. We all know that one of the ways that notice is typically given is through computers. If they have a computer index that says these 10 people did, that's fine, Your Honor. I'm okay with that. Maybe it went to spam. I'm not saying that they intentionally left 10 people out. I'm saying that there were at least 10 people that did not get the notice, that have come forward and said, did anybody else hear about this? I'm not necessarily saying it's their fault, although when you start talking about elected officials and things of that nature, would have thought they would have come up and filed with the court some proof that there had been some notification to hold this election. And then probably maybe an attendance sheet or a voting sheet that said that they did, in fact, elect them and they were the duly elected people. They have not proven. And, Your Honor, I think most instructive is the magistrate's directions that says that they are not entitled to claim the ownership or their position based on the weakness of the defense. They are only entitled to look at their strengths and what they can present to the court. And they have failed to present to this court anything more than a bunch of letters and emails back and forth that are not in any way, shape, or form authenticated. Obviously, the South Carolina GOP, they could have come down here. We've had this continuance for 30 days now. And to Mr. Boyd's credit, he and I exchanged a number of telephone conversation or telephone calls. We weren't able to get together on it, and we were not able to work it out. And we appreciate the court allowing it. I think, Your Honor, that everybody in this courtroom that is with the Horry County Republican Party wants this thing to be resolved and wants it to be a common front and wants it to be, once again, as it's not been in quite some time, a common front. However, surreptitiously going behind and doing these type of maneuvers and misleading everyone into trying to propose that a claim and delivery is an appropriate method to determine the officers and the duly elected officers within the party is completely inconsistent with that endeavor. And, Your Honor, that is necessarily what they're asking this court to do, and not notifying this court that there is an ongoing litigation that is right across the street, and in fact telling this court that they're not even asking for the bank accounts when they're clearly asking for the bank accounts, which exceed the jurisdiction of this court, Your Honor. Clearly. Either that or they're not paying very much close attention to their leader, Mr. McKissick, who, again, is in Columbia. The law firm that some of the materials and the records are in Columbia, the attorney's office. Necessarily, they have conducted an audit. They have reason to believe that there's money that needs to be accounted for. They're not saying that it was done illegally or it wasn't done legally. They don't know. That's the purpose of a forensic audit, is to figure it out. But if they necessarily have to give this up, it would take this court to order them to go to their lawyer's office, for which, coincidentally, they have had, that lawyer's office, as I spoke to him last week, has had absolutely no contact with the South Carolina GOP or Mr. Boyd in any capacity that was requesting this. If they were going to go forward with that, you would think the GOP would be doing a claim and delivery in Columbia and not down here. But convenient enough, everybody that can authenticate any of these, what the South Carolina Election Commission says really has no moment to this court. They have an opinion. If they want to come to the Court of Common Pleas and they want to express their opinion and the court finds it irrelevant and it finds it instructive, fine. That's up to the judge over there. We're talking, and I'm defending purely a claim and delivery. The question is, Do they have standing to bring it, as they've not proved that they are duly elected? And there's only 3 plaintiffs. They have not brought in the Horry County GOP, or excuse me, the South Carolina GOP has not become a party. I would submit to the court we might have a different issue on that if it is. They have to have the right, the standing, and they have to identify what it is they want and where it is with some degree of specificity. And it cannot exceed $7,500. And I'm not sure what part of the law they're hung up on there, especially when there is a pending action in common pleas. And as the court's aware, when you file an action in common pleas or before this court, any and all claims, whether related or unrelated, are subject to be attached to that particular thing as long as the parties are the same or have similarly situated control over the issues that are involved. They're simply trying to skirt the law, Your Honor, and that should not be stood for. Thank you, sir.
All right. So there is, I'm assuming, I don't know this, there is a suit in common pleas about the validity of the election, I'm assuming?
No, Your Honor, that's a pre-suit petition. It is not. It is a petition for pre-suit discovery. It was launched by the Sweeney Wingate Barrow firm in Columbia by the former officers of the HCGOP. I don't believe there's been any response to it, Your Honor, but it relates to the alleged activity of the prior administration of the party, Your Honor. It really has no bearing on any of the events that are before you today. It is an ongoing matter that, at least for now, is being pursued by the party. But, Your Honor, that's like saying...
It's a discovery action?
It's an authorization for... It's a petition to authorize pre-suit discovery, Your Honor.
But there actually is a CP suit filed.
It's a CP petition to authorize pre-suit discovery, Your Honor.
Okay.
Yeah, I believe that was included, but I have a copy for the court if you'd like.
Submitted a lot of stuff.
There is a chance, Your Honor, it's not there, but I do have a copy.
But, Your Honor, if I may, that is akin to saying...
Petition for pre-suit discovery.
Yes.
Right. Dream of Purdue.
Exactly, Your Honor. She is a former co-chairman of the party. Your Honor, that's akin to saying somebody who is being removed from office at the end of their term, they file a suit and it's ongoing when their term is up, and somehow that they've locked themselves into their position by virtue of the fact that they have ongoing litigation. It just doesn't make any sense, Your Honor.
Sweeney Wingate Barrow. Okay. Granted, and Ms. Hannah, you represent...
Can I just briefly respond?
Sure. Go ahead.
To what was, I appreciate Mr. Herman's efforts, Mr. Von Herman's efforts, but Your Honor, we're very clear. This happens all the time where you have clients who have multiple claims, and you slot some in the magistrate's court and you move some over to common pleas. It's very clear from our pleadings, Your Honor, we're not asking for the money. We're asking for the financial records related to the accounts, the bank account records, the statements, etc. Clearly of nominal, if any, monetary value in and of themselves, but we specifically exclude the accounts from the claim and delivery action because they do well exceed the jurisdictional limit of this court. But it's well within our right to do that, Your Honor. Further, as it relates very briefly to the other property that Mr. Von Herman complains about, whether it's a password or whatever, if there's anything in that list, Your Honor, that the court finds is not appropriate for a claim and delivery action, the court can simply exclude that. But I think on that list there are quite a few things that are appropriate for a claim and delivery action. And just very briefly, Your Honor, this business about not having quorum at a meeting or not having other procedural rules met, Mr. Von Herman is inviting the court to do something which we've said is improper, and I maintain is improper, which is to involve itself in the internal affairs of the Horry County Republican Party or any political party, Your Honor. If there was a problem with any particular quorum or at any meeting today, tomorrow, at any time, The way you address that is to participate in the meetings and to raise those objections as they come up, as these things happen. But to try to attack it collaterally several months after the fact in a magistrate court proceeding is not proper, and it would do exactly what the Oconee court wisely avoided, Your Honor, which is saying we're not going to get involved in the nuts and bolts internal proceedings of a Republican Party. And so, Your Honor, I would submit to you that Mr. Von Herman is right. There is one party in South Carolina, and what the Election Commission at the state level has to say about this not only is telling, Your Honor, not only is it probative, I would submit to you it's dispositive. When he says there's one Republican Party in the state of South Carolina, we choose it, that's our job, and it's represented by Drew McKissick and the current officers at the state level. When they say the officers of the Horry County Republican Party are XYZ, the plaintiffs herein, then that's the rule. That is the designation currently honored by the South Carolina Republican Party, and it's the designation that ought to control these proceedings. And if there is Republican Party personal property out there, Your Honor, that falls within a permissive claim and delivery action, it should be well within the authority of this court to order the former officers to return that property to the new officers. Thank you.
Gotcha. And Ms. Hannah, do you have, I know you represent the state GOP, right?
Yes, sir, that is correct, Your Honor, if I may be heard.
And do they, yeah, please.
Thank you, Your Honor. I am here today on behalf of the South Carolina Republican Party and Drew McKissick, who is the chair that was referenced previously by Mr. Boyd. I believe that you have a letter in your file. Your Honor, despite the arguments that you've heard today, the South Carolina Republican Party sees this as very simple. Quite candidly, Your Honor, this matter that's before the court is just a claim and delivery. So the only question that Your Honor has to answer is who owns the personal property and who is entitled to possess it. Your Honor, if I may pass up some law that I think, Your Honor, will provide a pretty clear roadmap on the direction that this court can go. If I may,
Certainly. Have you provided that to Mr. Von Herman?
I believe this is already in his memo, Your Honor, but I do have a copy of that. Under South Carolina Code 7-9-10, Your Honor, thank you. That sets forth that under the law, and I'm going to break this down, under the law it says in order to be a political party in the state of South Carolina, you got to be recognized. You got to be recognized by the State Election Commission. There are only the second thing that you have before Your Honor is a certification by the State Election Committee. There is only 9 parties in the state of South Carolina. Only one Republican Party. Only one. The second thing you have before you are the rules of the South Carolina Republican Party. Within the South Carolina Republican Party rules, it says there are divisions that fall under the umbrella of the state organization. And then beyond that, Your Honor, you have the Horry County Republican Party bylaws. What that also says, Your Honor, and I'm reading from it, their job is to promote and comply with those Republican goals articulated by the South Carolina Republican Party platform. The point that I'm making, Your Honor, is the South Carolina Republican Party owns this personal property. The Horry County Republican Party is merely a division that sits under the umbrella of the state. And so the question before this court, who owns the property? Very clearly, under the statutes, under the rules, and their very own bylaws, the state organization owns this personal property. Your Honor, I give you an analogy. This will be no different than the Horry County Clerk of Court walking in and saying, I quit. If Renee Elvis quits, she can't go in, take her desk, take all the papers on her desk, take all the files in the Horry County Courthouse, pack them up, throw them in her car, and drive away. Those items belong to the state, Your Honor. Those are items that belong to the state of South Carolina. And so by way of analogy, Your Honor, whoever is the chair of the Horry County Party doesn't have a right to take those items, whether it's Mr. Boyd or whether it's Mr. Slagle. Those items belong to the party itself. As far as being able to identify those things, Your Honor, we're not asking, strangers to identify this personal property. These are people who controlled it, who held it, who were the chair, the secretary, the vice chair. They controlled these items, so they know what tables we're talking about. They know the printer we're talking about. They know the files, the bank records. So it's a bit facetious, Your Honor, to actually say, well, you can't identify. Of course, everybody in this room knows what table and chairs we're talking about and knows where the bank account is held. So, Your Honor, you do have jurisdiction. The amount that we're asking for does not exceed the $7,500. We can easily identify where those items are. Mr. Boyd did an excellent job of making these arguments and setting it forth in his complaint. And so we would ask, I would join in his request for relief and ask this court to return the property to the rightful owner, which is the South Carolina Republican Party and the Horry County Republican Party. Thank you, Your Honor.
Thank you.
Now, just briefly, I disagree. I agree with her to a certain extent, but I disagree to a certain extent. And to that, I say this. Everybody in this room does not know where it is. There is not one set place that these items are kept. And there's often donations. There are often people that bring in, as officers, we need a printer, we need whatever. But the law doesn't recognize the fact that because they know what it is, the law requires that the organization or the people that are claiming the claim and delivery, that they identify with specificity and that they know where it is. Our clients have nothing. They have the burden of proof. They brought this. They chose this form. And they have to abide by their rules and the rules of the South Carolina Republican Party. And again, if the South Carolina Republican Party was here and they were a party to the action, we may be talking about entirely different things. What we're doing now is we're talking about jurisdiction. We're talking about standing. We're not talking about the merits of the case. We can get into that if the court disagrees with me. I'm okay, with that. But the fact of the matter is, the South Carolina GOP has asked for and is asking this court to allow in their own filings the accounts, the bank accounts. And they're also limited to personal property, for which they've asked this court to give that is not personal property. Out of the 9 items, I have no idea where most of this stuff is, and I really doubt they do. They have to prove that it's Horry County. They have to prove that under ordinary circumstances, not that we can all go and get in a van and drive to some particular place so we can do a claim and delivery. They have to prove they know where it is and that a law enforcement officer duly ordered by this court could walk in and identify those items, collect those items, and return it, therefore avoiding any unnecessary exchange between the parties. The other thing they have to prove is they're duly elected according to the rules, and they've yet to do that. They keep saying, we're just going to ignore the quorum rights and the rights of the constituents to come in there and the ECs to vote. We're just it. We're the people that get to decide. There is nowhere in the Horry County or South Carolina bylaws that says that that Drew McKissick or the head of the South Carolina GOP get to appoint the local folks. In fact, just the opposite. It says in their bylaws, and again, I really don't even like the fact because I think it applies equally to all organizations in a claim and delivery action. If this was posed as a different type of action, then perhaps, yes, sir, the court may or may not have jurisdiction. I believe it would be across the street. But in this case, we're talking about a claim and delivery, and there are specific requirements that they must prove to get this court to order that these items be gone and retrieved. It does not, a claim and delivery does not in any way, shape, or form compel any defendant to go locate, return, or do anything of that sort to assist the plaintiff. The plaintiff is essentially coming to this court and saying, we are the rightful owners, and therefore the court should give us these, and we have complied with the affidavit statute by doing this. And they've had now 45 days to do that, and they failed to do it time and time again. They have not amended their pleadings. They have not amended their affidavit. They've attached the head of the GOP, who didn't find it significant enough to come down before the court and say, I didn't say I wanted the accounts. We're not asking for those. Why would they ask for everything, all the bank records and everything else, but they're not asking for the accounts? Doesn't make any sense. What they're trying to do, Your Honors, they're trying to circumvent the necessary fact that the Horry County GOP is subservient in a division of the South Carolina GOP who is not a party to this action. And it is completely not correct to compare this to Renee Ellis. Renee Ellis has a clerk of court's room where the files are kept. Everything in there is owned by Horry County. There are no donations. There are no volunteers. There are no people bringing in personal property to put it in there. I doubt that Madam Clerk, Elvis has one lent computer. In fact, they keep inventory every year. They got little tags on it. In this case, that's not the case. And so what they're asking this court to do is to rule on something that is completely inconsistent with what their actual goal is, with the hopes that the court will just turn a blind eye to the regards of who the duly elected and ultimately give them the right. Well, the problem is they haven't brought that before the court. They haven't shown that they're duly elected or that they're anything else. In fact, they just admitted that they're not really the parties of interest, that the South Carolina GOP would be the party of interest. So and nowhere in the plaintiff's name or caption is the South Carolina GOP, which necessarily means the parties that have come before this court today are not the parties of concern or with any type of interest in it absent the South Carolina GOP. And again, I believe that they would have a different case. I believe that maybe venue may be proper except for the account. And I believe that for that purpose, the court should dismiss it. If they want to rebring this and they want to comply with the statute and they want to be to a greater degree of specificity, that's fine. If they want to contact the lawyers, if they really are the duly elected people that are supposed to be representing the Horry County GOP, then the attorney in Columbia would necessarily be, they would necessarily be employing him and not these folks. But right now, they are being employed by the Horry County GOP. They have expended Horry County GOP funds on an attorney, and these folks have authorized it, and these folks have gone and voted and not been interfered with at all. But when it comes down to the dispute, now all of a sudden we're not going to have anything to do with it. It just smells bad, Your Honor. I mean, they're asking this court to go out on a limb for the purpose of something that they didn't even comply with giving the court enough information for. For that reason, Your Honor, 12b-6, they have not given you a means or a complaint for which you can offer them a remedy. Because it really does become a sort of an all or nothing, minus the fact that, obviously the court, I don't think has the authority to tell these folks that they've got to go look for property. I think it's their job to identify it. And I think they have to prove, and I don't want to get away from this too far, they have the burden of proof. And it has to be their proof that overrides the concern.
All right. Anything else? Go ahead.
Very briefly, Your Honor,
Certainly.
I apologize, but if the defense that Mr. Herman is offering the court, if ignorance is the defense, and Mr. Von Herman doesn't know where any of this property is, maybe we should put his clients on the stand. If anybody in the courtroom knows where the property is, it's Mr. Von Herman's clients. And as either officers, if you want to take him at his word, or former officers of the party, they've got a fiduciary obligation, Your Honor. They've got a duty of safekeeping to maintain this property on behalf of the party of which they were officers. And again, Your Honor, we're very explicit in the pleadings. In the letters leading up to this litigation, nobody wanted to be here today, Your Honor. We didn't want to trouble you with this. We would hope that wouldn't be necessary. But in the letters leading up to this litigation, of course we asked for everything, including the $30-something thousand in the bank. But we specifically excluded that from this action because we know Your Honor doesn't have that limit of jurisdiction, but Your Honor does have jurisdiction over the personal property. I'm not going to beat that dead horse, but I just want to briefly respond to Mr. Von Herman again. And again, as far as these issues of quorum, again, Mr. Von Herman is inviting the court to involve itself in the internal meeting proceedings of the Republican Party, which is not proper. And if there was any per se impropriety about us being here today, we wouldn't have that magistrate court decision from Oconee County. Your Honor, there's nothing per se improper about us coming here as current officers of the party and asking that the personal property rightfully be returned. As to Mr. Von Herman's point that the real party in interest is the South Carolina Republican Party, they're here today, Your Honor. They've retained counsel to appear. It just so happens, I believe Mr. McKissick is out of the state at a national meeting of the Republican Party, I believe in California. But Ms. Ms. Hannah is here today, so you can treat that as a de facto motion to intervene in the proceedings, but the party has made an appearance here today, Your Honor, so in point of fact, they are here today, Your Honor, so they are at least to the very, and I would ask that the motion be entertained, Your Honor, that we amend our pleadings to include them if as a party specifically, if that will give this court standing to proceed, if this court thinks that's a legitimate issue. But in point of fact, Your Honor, Ms. Hannah is here today on behalf of the South Carolina Republican Party, and she's given you, the court, her position on this matter, so I'm not going to reiterate that, but for all these reasons, I think we're here today properly, and this court has authority to rule, it has jurisdiction, and it should rule on those aspects of the case that it can.
Is there a motion to amend the proceedings before the court?
With Ms. Hannah's consent, yes, I would move to add the State Republican Party as a plaintiff in this action.
Yes, Your Honor, that would be great.
And I want to hear from you, Mr. Von Herman.
Objection, Your Honor. I mean, certainly we're not here prepared to argue about the South Carolina GOP. We would have subpoenaed in Mr. McKissick, and we would have subpoenaed in a number of people had that been done. That's clearly prejudicial. What they've done is they got 3/4 down the road. They realize they screwed up. Now they're going back to try to fix it.
Well, here's what I don't necessarily want to send anything back to across the street if I can hear it. Monetarily, do I have jurisdiction? Yes. Because what they've asked for. Now, granted, the broadness or the scope of what everybody wants, I can go through. There's 9 different things, and I don't even know what the ninth one even means. But the scope of it, I don't know. And I think if we get people testifying that says where X, Y, and Z is, then we'll know. I don't want to burden the circuit court for something that possibly I can hear. And I understand that if I grant the motion for the state GOP to be brought into this suit, you've got rights to prepare for that as well and subpoena whoever you want to as well. And I can't go forward. What the magistrates or any magistrate court or summary court has to do is determine ownership. And I understand your argument, and I understand theirs. Should have been filed under the state GOP, Republican GOP. All it is an agent, not an agency. It's a spinoff from the state GOP. I think it says that throughout the paperwork. So I'm apt to grant that motion to amend, but I'm going to give you a chance to go forward with that said. As far as some of these things, like all corporate records, I don't know where all that stuff is, and maybe that's a part of the case that we're going to have to get into. Attendance, a lot of these things are very arbitrary, or whatever word I'm trying to look for. It's going to be hard to sort of figure out. I'd say most of the claim and deliveries that I get before my court are boyfriends and girlfriends splitting up, and they want their hair dryer and all pictures and stuff like that. It's very random. And so, of course, I go through one by one, and we sort of figure it out from there is what I do. So I'm used to arbitrary stuff, and this is no actually any difference. The first 3 are, I'm assuming there's an office somewhere, right? Is there a Republican office, or is it just anywhere? I'm
not aware of any physical office, Your Honor.
So there's not?
No real estate. No.
So I'm asking if the former officers, they might have it at, so is there an actual place where you're knowing the chairs are in Horry County, or are they in Georgetown County, or the tables, the printers, or?
I think we can take testimony, Your Honor, if Your Honor wants to take testimony, but I don't know the specific location of those items at this moment.
Okay. But you're assuming they're in Horry County?
Yes.
Okay. Let me, and are you making a motion to amend to make it a, well, if I do that, I'm not sure if I amend it to make it the state GOP, any representation of the state has to be heard in common pleas court. Like if somebody sues the state of South Carolina or Coastal Carolina University, I don't have jurisdiction.
Well, I think that's actually a separate entity, Your Honor. I think that statute, if the state was a party, that would be different. But as to the state Republican Party,
Okay.
I don't think that statute
All
applies.
right. And if I grant that motion, I believe I do have to give Mr. Von Herman some time to prepare his defense, yeah.
Your Honor, in Mr. Von Herman's motion to the court that was filed this morning, much of the argument was that the state Republican Party was not present. So we are here today. He anticipated it. Much of his motion is directed directly at the South Carolina Republican Party. So because we went forward on his motion to dismiss, I think it's most appropriate that we are here today. We're an interested party, and we would ask the court, in the interest of efficiency, to proceed forward today with us as a party, or in the alternative, if it holds things up, if Your Honor feels compelled that you can rule just on behalf of the Horry County Republican Party as an agent of the state party, then we would ask that as well. Thank you.
Okay. Well, and I'm assuming, I don't know this, that Mr. Von Herman's going to want to be heard by Mr. McKissick, or will he be a party to the case?
Your Honor,
Or subpoenaed?
and I don't know, I would submit to the court that the method for which would probably be the most streamlined and perhaps it would probably help all parties is not to ask this court to make findings, dismiss it without prejudice so they can refile it. Then the court doesn't have to worry about any continuance or anything like that. Because the bottom line, Your Honor, is they have not proven that they are that they have the duly elected officials here. And we would have to do further inquiry as to whether they abided by their law, because you have to understand, they keep saying that should not necessarily involve this court in the inner functions of the Horry County or the state GOP. That is not what we're asking the court to do. The fact is the election laws, the South Carolina election laws, require that these 9 entities that are recognized operate under the bylaws as established and voted on. So we are talking about a state law. We're not talking about bylaws. So, Your Honor, what we would request is just a dismissal. If they want to refile their action, and perhaps that'll give us some time to again, go back and rehash, over this, because it really needs to, at the end of the day, everybody in this room needs to come out with a common front whether they agree or disagree about the politics. It's the only way to put the party back together. And, that is the remedy. They have the burden of proof. They have not met the burden of proof. I appreciate Ms. Hannah coming today, and I appreciate that they are continuing to pick and choose what parts of my argument that they have to make. But the fact is, Your Honor, this we're here right now on is a motion to dismiss. We haven't even gotten to their claim of delivery. Now, a lot of the same arguments would be made, and I wouldn't bore the court with my continued arguments. But I agree. I object to them being put in as substitution of counsel, substitution of parties. It should have been brought unto them. They should have hired Ms. Hannah a while ago. They've had 45 days or better to amend the complaints and do all that as a matter of right. I would not have objected to that, and I don't object to that now if they want to refile it. But as we sit in here today, you're right, Your Honor, there's a whole lot of guesswork here is going to have to be done. And I don't think that's appropriate for something as important as this. And hopefully, once again, as I was last time, I always have that back of my mind, the hope that we can work this thing out and come out with a common front. But we certainly can't do it, with a gun to our head.
All right. Yes, sir.
Your Honor, if I may, just very briefly, this is not about restoring the party. We're here as a last resort to recover party property that is wrongfully retained and in the possession of former officers. That's why we're here, Your Honor. And I don't even necessarily, I would consent to the admission of the state party as a party if that will help this court, but I don't believe that that's a necessary requirement, Your Honor. This I would, again, commend to the court the magistrate court decision from Oconee County. State party's not a party there, and that magistrate felt perfectly empowered to issue an opinion directing the disposition of personal property that belonged to the county party. It's not a federal case, Your Honor. It's not rocket science. It's simple. It's no more complicated than this. The state party is a single legal entity. And it is just like Howie Knapp describes in his email, Your Honor, from the state election commission to the Horry County Election Commission. There is one Republican Party in South Carolina. It speaks through its chairman and executive director. They have designated who the current officers of the party are. You, the Horry County Election Commission, should abide by that designation. And they've designated Reese Boyd, Robert Visconti, and Michael Connett as the current officers of the Republican Party in Horry County. It's no more complicated than that, Your Honor. Mr. Von Herman is attempting to split infinite hairs with you in an effort to convince you that we need to, redraft this complaint and refile it in federal court and have a great inquisition about all of this because that's necessary. It's not necessary, Your Honor. This is a simple matter. And if Mr. Von Herman doesn't know where a few chairs and a printer are, we can put Mr. Slagle on the stand. Mr. Slagle, do you know where this property is? It's not rocket science, Your Honor. It's very simple. It's very straightforward. And Mr. Von Herman filed a 30-page, or I don't know exactly how many pages it is, but he filed a fairly lengthy motion this morning that I just read. I'm not unduly prejudiced by that. Ms. Hannah, by her presence here today, not unduly prejudicing Mr. Von Herman. If the court feels like Ms. Hannah and the state party need to be a party to this proceeding, Your Honor, we can add them. That's not unduly prejudicial. It happens all the time, Your Honor. But as far as I'm concerned, it's not a requirement, and it shouldn't be absolutely necessary for this court to do that in order to proceed.
All right, and I'll hear from you one more time, Mr. Von Herman.
At the expense of feeling like one of those pop games at the arcade, popping up and down, Your Honor, if we object to the inclusion of them as another plaintiff, I think it's inappropriate at this time. If they didn't recognize that in the last 45 days before they brought this action, it's certainly prejudicial. We have subpoena power. He keeps talking about putting these folks on the stand and asking them questions. Well, we have that right too. And again, Mr. Boyd keeps ignoring the fact that he has the burden of proof, and he has to do it based on his strengths and not my witness or my weaknesses in any way, shape, or form. And so the first person I would call, of course, would be Mr. Boyd. And he would take the stand and he would say that the law of the state of South Carolina says they have to follow their bylaws, that there was not a quorum, and therefore it was not an official election, and they don't have them as duly elected officials. And what they're trying to do is get this court not to be involved in that. Just because some entity recognizes it for an email that they're not even here today to say that I typed that email and let me tell you why I found it. That's putting the court in an awkward position. These folks, when you start talking about the deprivation of items, personal property, and things like that, those are things that are just not getting back. I mean, that's gone. And again, they did not fulfill the obligations of the statute, which is the affidavit. That in and of itself, just that alone, is enough for this court to dismiss the action. I am not, quite frankly, so sure that I understand why they are so opposed to me agreeing to a dismissal without prejudice, where they can actually clean up their mess and not bring it before the court in a shotgun fashion and start trying to confuse the court and confuse the court of common pleas. I don't understand it, because what they're doing is they're going into odds with themselves. You've got the Horry County GOP, who claims to be officers, disputing with the South Carolina GOP officers or representative who is asking for the bank account against these folks are the Horry County GOP officers, and they're saying we're entitled to it. And if we're going to start getting into that, then necessarily we're going to need witnesses. Affidavits in and of itself is not going to do it. We're going to need the right parties involved. So they've got a chance with the court doing that with my consent, that they can bring it back and they can raise the issue with the proper party, as long as they carried the burden. But today, they didn't do that. And they should be ruled against it, Your Honor. They keep bringing this Oconee County thing up. But you know what they didn't bring? They didn't bring it to the court's attention until I did. And I did for the purpose of letting the court know in full disclosure that there were other issues out there. We don't know what the issues were, but there were other court hearings, and I wanted to make sure the court had the ruling. They didn't bring the fact that there's pending litigation and common pleas. They've never mentioned that to you. I mean, how many things do we have out there that we're really not sure about, that they haven't brought to anybody's attention that is relevant? What a magistrate ruled in Oconee County has absolutely nothing to do with what we're doing here. And they're conflating their entire opinion so they can persuade you that another magistrate did it, so you should too. Well, that's not to say that got it right, or that I'm asking you to get it right. I think that the best thing we can do, and I implore the court to give us an opportunity, is let them get it right, let them figure out exactly what it is they want. I'm even willing to help them with it. But the fact of the matter is, this is insufficient on its face to be valid.
Well, I'm not one to. Yeah, we kick the can down the road a lot, and I hate to kick the can any more than I ever do, and I don't want to kick this can anymore either. I think that monetarily I got jurisdiction. Substituting the state party who's represented here today, I understand your objections to that, but I'm not necessarily opposed to that going forward with that. And I don't think.
And I would just note that's a supplemental addition to the proceeding, not a substitution.
I got you. Well, I used a bad word. Wrong word, rather. But substitution. So as far as the arbitrary things that are asked for, I do that all the time. So it's usually what the court's posed with in any claim and delivery case. So we got to figure out what's what and who owns what. So I'm not opposed to having testimony go forward with that. So as far as the motion to dismiss on jurisdiction, I understand your objections, but I could go forward with that. And what was your other motion on whatever
Motion
point?
for lack of standing, Your Honor.
Lack of standing issues before the court, which is about what they're asking for, right?
No, Your Honor. Your Honor, the fact that they are not the parties in interest in this particular case, and that they are not the leadership of the Horry County GOP for failure to comply with the state law.
And there was no objections to how we got here in the first place. It seems like the prior or former officers resigned, so new ones had to be elected, and so these folks are out, and then you can't come back in and unresign. So obviously it had to be somebody elected, and I don't know if that was proper or not, but that might be something that's appealable on if I were to go forward with the case. So I'm necessarily respectfully denying that motion. Anything else?
If I could just clarify that,
Sure.
Your Honor, their resignations were effective September 30th. In other words, they wrote a letter on, I believe, the 12th saying effective September 30th. They withdrew prior to the expiration date, the resignation date. So they actually never did. And when you go to look, and the way the bylaws are written is first they go to state law, then they go to bylaws, then they go to Robert's Rules of Order. In any of those three documents, there is no prohibition against withdrawing your resignation. And so their withdrawal of resignation, there was not any party business that was not taken care of. And in fact, it was actually taken care of and meetings scheduled on behalf of these folks. These folks continued to go through. The only one that did not revoke his resignation was Mr. Helping, and he is not here today, and he's not a party to this action. So there is no specific rule, Robert's Rules of Order, bylaws, or anything else that says that what they're doing is inappropriate.
So, those are wrench in it. Is that true that they?
Your Honor, if I may, again, that asks this court to intervene into the internal workings of the party. If you're going to raise an issue, Robert's Rules of Order is a parliamentary procedure. It's not authority for this court to take after the fact and say, well, this was improper for this reason or that reason. If, in fact, the party had a meeting and these folks would object to the manner in which that meeting was conducted or the number of people who were present or any other objection that would be based on parliamentary procedure, there is a specific appeal route for that under the rules, Your Honor, but this is not the time to raise that issue. If you object to something that the chair does at a meeting or the way a meeting is called to order, if you believe there's no quorum, the time under Robert's rules to raise that objection is contemporaneously. You can't come back 6 months or a year later and say, well, you didn't have a quorum. You didn't participate in the process, so you weren't there to object, so the process went forward. And in fact, if you had participated, Your Honor, and you did have an objection, and the chair ruled against you, well, you've got an appeal process directly up to the state executive committee to address that within the confines of party procedure. That's where that appeal goes. That appeal doesn't go here. That appeal has long since been waived. If you've got an objection under Robert's rules, you make it, but you have to be participating. The problem is these folks took the position that this is all, excuse me, Rob, this is all fake news. So there's nothing to see here. Let's just do our own thing. And they didn't participate. And they did not participate in the process. And so now they want to come back many months after the fact and tell you, well, they didn't have a quorum at that meeting. Well, that objection or that appeal, Your Honor, there is a process to raise that objection, but they didn't participate in that. And that has long since, at this point, been waived, and it would be an improper, it's an improper objection at this point, Your Honor, because again, that would involve this court in the internal proceedings of the political party. And I know Mr. Herman doesn't like this Oconee opinion, but he makes some really wise points, Your Honor. He says the parties presented testimony, evidence, arguments. The dispute arises out of the ownership and possession of certain assets belonging to the former officers of the Oconee County Republican Party. It is the legal duty of the court in a claim and delivery to determine who should have legal possession of it if it is being wrongfully detained. It is not the duty, role, or position of this court to determine which individuals are in their respective leadership's roles legally or illegally. To do so would violate the canons of judicial ethics by these parties attempting to get this court to participate or to determine a political question. And so, granted, that's not binding on this court, Your Honor, but again, for this court to try to wade into the internal proceedings of the Republican Party that occurred in September or October or November is simply not, it's not appropriate for this court to attempt to do it, but it's also not a proper objection at this time. This court, as I have said, it's not complicated, Your Honor. The Republican Party is one entity in South Carolina. The Election Commission has authorized one Republican Party. There are not 46, there are not 47, there is one. And Drew McKissick and Hope, what's Hope's last name? Walker, excuse me. Hope Walker are the duly appointed executives and spokespersons for that party, and they have issued, there are multiple letters, Your Honor. That's why there are a dozen exhibits to our complaint. Mr. McKissick has written multiple written pronouncements as to who the officers of the Republican Party in Odie County are. And it's as simple as that, Your Honor. So the question becomes, what personal property is there that has been wrongfully retained by the former officers, and how can we get that back in the current officers' hands for those items over which this court has jurisdiction?
All right. Anything else?
Just one more thing. The plaintiff is not here. We have a right. We are prejudiced by the fact that we are not able to hear what Ms. Walker and Mr. McKissick said. We're having to go on something completely different. We don't have anything more than some written letters, for which I have a lot of questions about this. He has just spent about 10 minutes harping on how, we had appeal issues and it's long since and all that, and then turns around and says, but the court shouldn't have to look at the internal workings of the Republican Party. I'm not asking the court to do that. I'm looking for the court to look at the South Carolina Code on Election Laws, which specifically says that they have to comply. If they didn't comply with their own bylaws, then this is a moot point. The only way that we can figure that out is for us to put Mr. McKissick and Ms. Walker on that stand and ask them. That's the only way. And without them, then it prejudices my client. There's just no two ways about it. I've never, in 24 years, seen where we're going to add a plaintiff in there and another party of interest because they now realize that they're not parties of interest and not have an opportunity to subpoena them in and have them here. If they were here, I'd be fine. If we could put them on the stand, but we don't have them here. They didn't think enough of it to come here. So state law is what I'm focusing on. They're talking about internal. I don't care about the internal operations except to the extent that the state law requires certain things in order to be recognized as a political party.
All right. And, of course, we have representation from the state office and I'm assuming it will prejudice your case if you don't have Mr. McKissick here or Ms. Walker here, right?
Absolutely, Your Honor. It's not like I can put the attorney on stand.
Can the state go? Can the defense go? The plaintiffs go forward without Mr. McKissick and Ms. Walker?
Your Honor, the actual knowledge that
some of these letters are going to be hearsay.
Well, Your Honor, there is a relaxed standard of evidence in this court. I think Your Honor is well accustomed to practicing on a lower standard evidentiarily.
Unless other counsel makes a...
But the bottom line, Your Honor...
Makes an objection, and then, of course, I have to make a ruling based on it.
The bottom line, Your Honor, is the actual knowledge that Drew McKissick or Hope Walker would have to bring to this would be somewhat limited. The events that we're talking about have all transpired in Horry County. And the folks who are most familiar with the events that have given rise to this case are right here in this courtroom. And the state Republican Party is represented by counsel here today.
Your Honor, he doesn't get to determine who I get to cross-examine, who I get to subpoena in now. Now we're getting a little bit out of hand. This is getting to be a one-sided show on his behalf. He thinks that he can bring it, tell the court, well, this is the way it is, and he can't subpoena him in, and he's not prejudiced. Absolutely. If they had decided to do this in the last 45 days, I would have issued a subpoena. And I'm with Your Honor. I don't like continuing to kick this down the road. But I do have to have 10 days to subpoena them in. I will do everything I can to subpoena them in and get those subpoenas out tomorrow if this court's inclined. And we will be more than happy to have a day certain.
Your Honor, Mr. Von Herman could have subpoenaed Drew McKissick or anybody else that he wanted to subpoena to be here today. This is disingenuous at best.
He wasn't a party. Why would I?
That would be the argument. But yes, ma'am.
Your Honor, on behalf of the state party, this has gotten way out of hand and way too complicated. It's super, super simple.
I understand.
The former chairman has possession of stuff that belongs to the state party. We don't need to be a party to this entity. When I say we, the state Republican Party doesn't even need to be here. We are here, Your Honor, just to show support to the court, just to confirm and corroborate what the Horry County Republican Party is saying. Quite simply, the chairman knows where this stuff is, and it's a half-page list of things that this court can cut to the chase, take some testimony by Mr. Slagle, or, Your Honor, we're happy to draft a proposed order that's supported by the South Carolina Code, supported by the rules of the South Carolina Republican Party and the Horry County bylaws that Your Honor has before you. We can cut right to the chase, draft a proposed order, and go get this stuff. In the alternative, if they're not comfortable, even though they had a fiduciary responsibility to keep the stuff, they can offer some testimony today to tell us where it's at. There's no reason to have Mr. McKissick or Ms. Walker come to this court and drag all of these people that are in this courtroom for a third hearing, Your Honor. We would ask that you rule, you have the authority to rule, you have the jurisdiction, you have a half-page summary of what these items are, and you can take testimony if you're unclear of what those items are. Your Honor, we'd ask you issue an order in favor of the Horry County Republican Party. Thank you.
Okay. Thanks.
And, Your Honor, if I may, just very briefly, it would be fine, as I'm reiterating a little bit of what Ms. Hannah has said, but it would be fine for this court, in my estimation, to issue an order that says, if you have financial records that belong to the Republican Party, if you have personal property that belongs to the Republican Party, then you have 10, 20, whatever time limit the court would like, so many days to turn that property over to the current officers of the party. I don't think we can do that and then see what personal property is rendered. And if it's nothing, if they say, well, we don't have anything, or they take a completely unreasonable position, well, we can have further proceedings. But if they give us, if they make a good faith effort to transfer the property that's in their possession to us, Your Honor, then we can be done as far as I'm concerned.
All right.
Now,
Yes, sir.
they are once again conflating the fact that there is a dispute between the fact that these folks claim that they are the duly elected officials of the Horry County GOP. Every one of their arguments has been that they are the duly elected members of the Horry County Party. That is where it lies. That is exactly where it lies. And to the extent that there needs to be hearings and there needs to be that type of information is exactly the reason this is appropriate in a jurisdiction for which, you know, can make those determinations, and that won't be, you know, going against a lower court or a different court. You know, their assumptions, if you buy them, absolutely. I mean, of course, yeah, we're the Horry County GOP leadership. Well, that's the date of their expiration is in April of this year. So really, all of the indications are that they are, in fact, the Horry County GOP leadership. They have completely acted within that scope. In fact, they're receiving bills that are being run up on the account of Horry County GOP. And they're having to issue checks. If that's not an officer's job or a secretary or treasurer's job, what is? So by de facto, they're recognizing that these folks are, in fact, the Horry County GOP leadership. Now, they may be acting outside of the scope of their authority, but we're okay with that. It's a Christmas card.
Your Honor, because they continue to get bills, because they've refused to turn over the keys to the post office box, so they continue to get mail, so they're arguing that that makes them the continuing officers of the party. This is so circular, it's silly, Your Honor.
All right. Right or wrong, make my decision. Let's go ahead, respectively. Deny your motions. I think we can go forward. And I'll tell you the reasons why. I've got 3 resignations from Ms. King, Mr. Slagle, and Mr. Treacy resigning as officers, and I think the state said they had to elect some other ones. Was it done right or wrong? I don't know. And that might be something that can be argued anyway. So as far as us going forward, we'll go ahead and proceed with your case. All right?
You ready to proceed, Your Honor?
Yes, sir.
Your Honor.
I understand your objections.
Thank you, Your Honor.
Okay, go ahead.
Your Honor, the plaintiffs would call Jerry McDaniel to the stand.
Mr. McDaniels, please come on up. Miss McDaniels, excuse me. And if you just, once you get up there, raise your right hand, please, ma'am. Do you solemnly swear or affirm the testimony that you give the truth, and the whole truth, nothing but the truth, so help you God?
I do, sir.
Just have a seat. And what's your name again?
Jim.
Okay, go ahead. Answer any questions. Go ahead. Go ahead.
Proceed, Your Honor.
Certainly.
Ms. McDaniel, would you state your name for the court, please?
Jerry McNeil.
And you might want to grab that microphone, Jerry, and just pull it up in front of you.
Sorry.
That could.
And Jerry, what is your address for the record?
1706 27th Avenue North, North Myrtle Beach.
And are you familiar with any of the events that we've discussed here today in this courtroom?
Yes, I am.
Tell the court briefly what your involvement with the party has been over the last year or two.
Well, in the past years, I was the vice chairman of the Republican Party, and prior to the folks that came in after me, I was the executive committee person representing the Horry County in South Carolina.
Okay. And are you familiar with the resignation that we discussed that occurred in September?
Yes, I am.
Okay. And are you familiar with a meeting that took place in October to elect new officers?
Yes, I am.
Okay. What's your understanding of that meeting?
That we elected new officers.
And who were those officers?
Reese Boyd, chairman, Rob Visconti, vice chairman, and Michael Connett as the executive committee person.
Okay. And are you presently involved in the affairs of the Republican Party in Horry County, as you understand it?
I'm helping.
Yes.
Yes.
In any way, did you attempt to recover personal property of the party after the election in October?
Actually, I think I'm the person that the past leadership or the other leaders, I'm the one that met them and turned over some keys.
Okay. And who did you turn keys over to?
To Barb Tracy.
And who is Barb Tracy?
She's the secretary.
Okay. And what was the purpose of turning keys over to Ms. Tracy?
Well, there was still, my husband had stacked all the chairs. And by the way, the chairs were not white. They were blue and silver. So we stacked everything very properly and cleaned out the storage units and wanted to make sure that it wasn't a mess for the other folks to come in.
Okay. And when you say you cleaned out the storage unit and you stacked the chairs neatly, when did that occur?
I think it was right before the convention, I think.
Approximately what date would that have been, if you recall?
I really don't remember the exact date.
Do you remember the year?
Yes, it was about 2 months before our convention.
In
2020, I think. I get the years
Convention was
mixed.
in 2021, I believe, wasn't it?
21.
Okay, so a couple of months before the April 2021
Yes. Mm-hmm.
convention. Okay. And at that time, do you recall what property was in the storage warehouse?
I think approximately there was about 70 some chairs, blue and silver chairs. I want to say 4 tables, 1 round table. There was some things that I used when I ran Victory, some big brown pots that I just left there for them to use.
Okay. And what is Victory?
It's when you get ready for, like, I actually worked on the presidential campaign, so I ran Victory. It's where you get help all your Republican candidates run for office and make sure that they have volunteers to help.
Okay. And so at this meeting in 2021, did you transfer the keys to this storage warehouse to Ms. Tracy?
I believe I did.
Okay. And where was the storage warehouse located?
It was a storage unit down past Lowe's on the left-hand side. I don't really remember the name of it.
Are we talking about Myrtle Beach?
It was in Conway.
Conway?
Yeah.
Okay. And down past Lowe's, are you talking about the 501 Lowe's?
On the left-hand side, yes.
Okay, all right. So the storage warehouse is behind that?
Mm-hmm.
Okay. And so after the election that we've discussed that took place in October, did you return to the storage warehouse at any time?
No.
Have you tried to regain access to that property?
No.
Okay. What's the last knowledge that you have about the whereabouts of that property?
The person that actually ran it said that it had been emptied out, that the stuff was moved, but I haven't gone back since.
Okay. When did you hear that the stuff had been moved?
I want to say about 7 months ago.
Okay. Are you? Is there anything that you've heard today in terms of our discussion of the facts, how the officers came to be elected, that you disagree with? How the current officers came to be elected? Do you agree with the discussion? Let me ask this question. Strike up. Who do you consider to be the current officers of the Republican Party?
Objection, Your Honor, irrelevant.
She is
not even an executive committee member. She said she had no dealings with...
I am executive committee person.
She's a member of the executive committee.
I am. I represent Cherry Grove, too.
So,
I'll allow it. Go
I'll
ahead.
withdraw it, Your Honor.
Okay, quick.
Jerry, in your estimation, who are the current officers of the Republican Party in Horry County?
Chairman Reese Boyd, Vice Chairman Mike Connett, Rob Visconti, Vice Chairman, and Mike Connett as the executive committee person that will represent us in Columbia.
And do you believe that it would be appropriate for the personal property items that we're discussing today to be returned to those officers?
I absolutely do.
Okay. Please answer any questions that Mr. Von Herman may have for you.
Good afternoon, Ms. McGaney. Ms. McGaney, thank you for your participation in the public party. It's certainly supported, and I've been with you on a lot of
Yep. Yep.
great candidates. Let me just ask you a few questions. Do you know the process in which a resigned officer of a party or the Republican Party will return to GOP? What is the process for them to be in a position?
We've never had anybody resign like this. And let me just say, out of all the counties in the state of South Carolina, we're the only county that has a provisional president in case something happens with the chairman and vice chairman. I specifically asked these questions with the party in Columbia, and they noted that we're the only ones this happened to.
And that's kind of all. How does the bylaw read that an officer position to be filled? Is that by appointment or is that by legislative EC?
Theses.
And what is required? How many of the ECs are required here?
I really don't remember exactly.
Let me see if I can help you. Would it be 2/3 or 4 of them? And that's correct. I'm sorry, he's got it here. They're checking the record.
Okay.
So it'd be 2/3.
Yes.
And how many are there of the?
I really don't know exactly.
If I told you there were slightly over 80, would you agree with
Yep.
that?
Hmm.
And how many were there the night that the election was taking place?
Oh, it was a lot of people. A lot of people.
Would it surprise you if there were 41 people there? That's a lot of people.
Oh no, it was more than 41.
What was the vote? Do you recall that?
Well, first of all, can I make a statement about some? You can't. Okay.
That's just not.
Okay. Go ahead, Bert.
How many voted? Do you remember the tally?
I don't.
Do you remember there being a discussion about there not being a quorum there that might get?
No. The last I heard there was, and let me just say this. I'm just coming back from a funeral, so I'm really, yeah.
I'm sorry, and I'm sorry you had
Thank you.
to do this that close. Because I know you are close.
Yes.
But would you take it at my word for if there were 41 people that were there, it would not be a quorum, correct?
Objection, Your Honor. He's asking her to assume facts not in evidence, and she stated she doesn't have a recollection.
Let me just say this. When the count was taken that night, I was walking around the room. They called a quorum. Now, the folks that were there,
I'm sorry.
the people that were counting.
Okay, and tell me who those folks were.
See, I really, right now, I just can't remember. I really can't.
But would it be the provisional chairman's duty to determine where the quorum?
Mike Connett, I think, was overseeing, but he always has like 3 people counting the votes. But that's all I remember.
Well, there's minutes of the meeting.
Yes, there were minutes.
Have you seen the minutes?
Yes, I have.
And do you have a copy by any chance?
Not with me, I don't.
Do you know where they're kept? I mean, can you get a hold of them?
The secretary.
Okay, so do we have a secretary here?
I don't know if the secretary of that meeting is here because it's different because we actually brought in and we voted on the officers after that as far as the secretary.
Has it ever been ratified? Do you know? Were you present during any ratification of the meeting? Minutes.
I'm not on the leadership, so I'm sure that would have been done with the leadership.
Well, yeah, I mean, to ratify the minutes, it would have taken the same people that voted.
Yes, it was counted. It was counted.
So was it ratified, I guess? And I know that these are kind of, I guess, technical terms.
Objection to form, Your Honor. I'm not sure about ratifying what he's referring to, but it's a fairly ambiguous question in my mind.
Did anybody approve the minutes, ratify the minutes?
Yes.
I'm sorry.
Yes, that's okay.
Daniel's very familiar with these
Yeah.
terms, so I kind of skipped
That's okay.
formalities. again, I know it fairly well. You indicated that you believe, or in your opinion, that these folks, Mr. Boyd and all of them, are the duly elected. If it were proven that there wasn't, or that election, would you agree with me that they were not the duly elected?
One thing that I don't understand is this, and I'll be straight up honest with you, that when they turned what I call turn your notice in, or they resigned, they said that Drew McKissick had not accepted it. So I was included in all these emails coming back. It's been accepted, and they kept saying it had not been, and it had been. And you know me, I'm not going to make up anything that's not truth.
No, I will agree with that.
Yeah.
But did you bring any details from the series to provide them to any of the folks we have here today?
I came in from North Carolina. Again, a funeral, a family member, so no.
I thought it was yesterday.
No.
So you go straight here.
I came in from Columbia, being with the President Trump yesterday. So before that, I came in from North Carolina.
So again, if somebody, I understand you're under a lot of stress, if somebody else had a recollection that there was not a quorum, or it wasn't the minutes were adopted, you wouldn't dispute that. I mean, you say, I'm under a lot of pressure. I mean, anybody expects you to come off a whirlwind tour of a funeral and everything you've been through, needs to be done with the president.
Objection, Your Honor. That's a multi-part question, and I don't even understand. I don't believe she understands the question.
I'm trying to be conversational. She's a friend of mine. I don't want to beat up on somebody. She's a friend.
Okay.
And she's not trying to hurt you. You just roll. I believe you ordered that we relax things that we're wrong. I'm sorry, Mr. Daniel. They just don't understand.
That's okay, Bert.
You're not a murder defendant.
No.
Would you just agree that you're under a lot of pressure and you're doing your best you can? And you could be wrong, but you're trying to be right.
I would say that night that the votes were counted, there was a quorum. I would not be part of something. I'm not about to say, hey, this is not the truth. And you know, I wouldn't do that.
But what about the numbers? But you don't have any idea of the numbers.
I wasn't involved in the counting at all.
So and I guess we're just getting into the fact part. You can't say for a fact that these people were here, these people were not. I mean, if it was close, it was close.
Well, they took a tally of everybody that came in, and their names were marked off.
Okay. And what if I
So they went through the same thing that happened every year, every month that I went to an EC meeting. Same thing happened.
And if I showed you a copy of the tally, would you be able to identify that? Would you know what the tally looks like?
No,
So you've never seen that tally?
I wasn't involved in that part.
Thank you.
You're welcome.
One just brief follow-up, Your Honor. Ms. McDaniel, how would you characterize the efforts of the new leadership to run the party since the October election? Has the operation of the party been hampered by absence of access to information, to passwords, to documents, to records?
I can be truthful.
Oh, absolutely. Yes.
We've been harassed by the other side, name calling, vile language. It's not at all what I would want to be part of a Republican Party. I wanted to make sure I've had to tell our people to be quiet, don't say anything. But it seems that we've been attacked nonstop. The name calling is not the. I've never seen a Republican Party act like some of the people in this court. It's been awful. I would never, ever do that to somebody. Not ever. To me, the group on this side has been more professional than some of the people in this court. And there's several in here right now name calling. I went through yesterday, sitting right there, calling me names what I wore to the Trump campaign. Calling us names. It makes no sense. How are we going to be united with everybody fighting all the time? The name calling, the name calling. I don't want to be part of that kind of Republican Party. If that's the way it needs to be, the whole party needs to be dissolved and start over. Because it's not fair for some people to try to do the right thing and others with the name calling and the vile and the smiling and smirking. When I just don't understand it. Why are you part of the Republican Party if you don't want to help support this country? I've been involved in politics, Your Honor, for many, many years. Bert Van Herman, you know me. Many hours. I've got pneumonia from campaigns, but I've never stopped trying. But what's happened here in Horry County these last 2 years is vile. It is absolutely vile. And I think that something needs to be changed about it, or we're going to lose this country. Now, some people can laugh and think it's so funny. It's not funny to me. I've got 3 grandchildren. 3. And it's sickening how people are acting in Horry County, the childish play, the name-calling. It makes no sense, Your Honor. It really doesn't. And I hate to say it, but I'm telling you, it's like child play to me. I've seen stuff in the last 2 years in Horry County that nobody should have to see on social media. All crazy stuff happening. It makes no sense. It doesn't.
Thank you. Ms. Hannah's got a couple of questions she may have.
Thank you, Your Honor. Ms. McDaniel, have you reviewed the list of personal property that the Republican Party is requesting be returned to it?
No, I haven't.
Okay. Are you aware that there are passwords to the website, bank statements, and things of that nature?
Let me just say this. When I was part of the Republican Party, I was asked, Your Honor, to turn over the passwords, turn over the website passwords, turn over social media passwords, and I did it. I did it because that was the new leadership. But I don't think that the new leadership now has the same respect being brought to them. I just don't.
And the items that you turned over were folding chairs, meeting tables, correct?
The chairs didn't actually fold.
Oh, okay, but they were chairs.
Yes, they're stackable chairs.
Perfect.
Yes.
And there were meeting records, records that you had in your possession,
yes,
passwords.
Mm-hmm.
And when you were no longer a member of the executive or an officer, you turned those items over to the next group. Correct?
Yes, I did.
And are all of those things that are listed on this item of personal property, are those essential and necessary to run the Horry County Republican
yes.
Party?
No, I'm going to object. She
Thank
said
you.
she hadn't seen the list. I mean, I don't mind her showing her the list, but I mean, she said that
I'll be
hadn't seen
happy
the list.
to show them, Your Honor. I read them out loud. I'll be happy.
And actually, I turned the passwords over to, I think, the past Vice Chairman, Jeremy Harp, and I think he resigned as well.
And Ms. McDaniel, would you please take a look at that list and indicate whether those are items that you turned over to Ms. Tracy?
I didn't turn over the records financial because I was not the treasurer. Neither did I have corporate records. I did turn over the passwords in the database to the last chairman, the co-chairman. Yes, the signs, the yard signs were in the storage unit. So that's, yep.
And Ms. McDaniel, the items that you just identified, are those items that belong to the Horry County Republican Party and items that belong to the South Carolina Republican Party?
Yes, ma'am.
Okay, so they don't belong to any individual. They actually belong to the entity, correct?
Correct.
Thank you. That's all the questions I have, Your Honor.
Just a couple. So, maybe I misheard it. The tables, the chairs, there's about 70 or so. They're not white with padded seats. They're blue.
They're blue, and
They don't fold.
they don't fold. They're stackable, stainless steel legs, stainless steel back, and Robert Raven is the person that got the money for us. So that's why they mean a lot.
Okay. By how much money? Now,
See, I couldn't tell you amount. I don't know. I'm not in the furniture business. I couldn't tell you, you know.
I mean, it's got to be, in the meeting table, they said 4, but they're actually 5. Can you kind of describe it?
There's a round. Well, I can't remember all the tables. I really can't. 3.
There's a computer printer here.
That computer printer, we use it every year at Precinct Reorg. So once we get all of the folders together, we have to have a copy. We keep a copy in Horry County, and a copy goes to Columbia. So that's why it's very important, and we're getting ready to go into precinct reorg. And if we didn't have that printer, it would cost a lot of money to go to Kinko's and,
Financial records you indicated.
No, I had nothing to do with that. Mm-mm.
Corporate records, you said
Nope.
you didn't have anything to do with those, right? I was going to make sure that got it right. It said meeting notes, attendance records, not who would have calculated?
The secretary.
And so, in other words, if they had them, they could produce the report to show that, like, for instance, the roll call vote, or the vote of the EC that elected.
Mm-hmm.
Okay. So they should be in their possession.
Mm-hmm.
There's some question about passwords. They have indicated where the GOP has maintained an account or presence of any type. What social media outlets is the Horry County GOP involved?
I think they have several Facebook accounts.
Several?
2.
I was just wondering, because I'm just not used to an organization having more than one.
And there were 2 websites. So I don't know if they do just have one website now or not. But I did turn in all the passwords to that.
Political memorabilia, how long has that been counted? So some of them say antiques, and I'm an antique lover. But
Some of it was back in. I don't know, about the thing. No.
that's a big part of Horry County history, and probably South Carolina political history. I think you probably had the first conference.
I did.
We're not shy. So, I mean, there's a lot of valuable, stuff.
I don't think there's, because when it was cleaned out, some of it had rotted from being in storage. We had to literally move stuff out of one storage unit because it was rained on and to another one. And a lot of the stuff had to be tossed out because it wasn't any good.
Do you understand this request any other personal property in your possession under the direct or indirect control that at any time is the rightful property of Horry County Republican Party? Do you know what that means? Because I'm not sure, I'll be honest with you. You're not thinking of that either. I mean,
I'm not part of the leadership. Some of the things, I don't get involved in it.
This, or if you give
No.
advice about it or
No.
anything like that.
No.
I agree with you. I mean, obviously, I think everybody's goal, while they might be trying to get the wrong way or different ways, is certainly inappropriate. Both sides of it, right? I mean, it's been just a hodgepodge for a number of years, right? I mean, this is not something new or anything. I remember when I ran.
I've never been through anything like this, Bert. Never.
But it's been back. You'd agree with
Well, things that happened in the past, I wasn't involved in it. I only know what's happened in the future. And it has, and the present. Yeah. Yeah.
Hopefully we're going to have this in the future. There we go. Have you engaged in any conversations, about any of the leadership or not leadership or the election or anything else on your personal Facebook page? Certainly entitled to. First Amendment covers that.
If you go to my Facebook page, and I'm pretty sure you have, it's basically Trump. It's everything positive. I'm Russell Fry. Well, no, I'm not. It's child play to me, really. All the name calling and all the, it makes no sense to me. We should be united right now, not fighting each other. And that's what's happening. We should not be fighting 2 parties. That's what it's like right now. Yep. You're welcome.
Very briefly, Your Honor. McDaniel, you said we should not be fighting. So there's maybe the court would need some help with this. The reorg process happens how often? Every 2 years?
Mm-hmm.
Okay. So we had a reorg and a convention in April of 2021. And there's another convention, county convention, coming up
Yes.
in a couple of months.
Yes.
2023.
Right.
After the 2021 county convention, when Mr. Slagle and the defendants, or when Mr. Slagle was elected chairman of the county party. To your knowledge, did everyone cooperate with the transfer of property to
Yes.
Mr. Slagle?
Yes.
So that included the storage warehouse that
Yes.
you discussed? As far as you know, did that include bank accounts and bank records?
Yes.
Did that?
And I don't want to interrupt Ms. McDaniel, because I know she has got more institutional knowledge than probably anybody, but I just don't know that it's relevant to the claim and delivery action.
It's entirely relevant.
I will tell you,
Your Honor.
it's very interesting in a personal conversation with her, because she can talk about and remember people that I don't even remember, and she got fond memories of Robert Reagan, of course. But I don't know how that had anything to do with whether or not they're entitled to 70 chairs that they couldn't even identify.
Well, go ahead and ask the question. For the sake,
Thank you, Your
we
Honor.
might be here till 6 or 7
I'm
o'clock.
going to wrap it up very briefly,
doesn't
Your Honor.
matter.
And so, Ms. McDaniel, after the transition of leadership in
Yes.
2021, was there generally, to your knowledge, cooperation with the new team?
Yes.
And
Yes.
was the property, the records, other items that they needed transferred to them?
Yes.
Okay. And you've already testified, but I'd ask you one more time, has the current leadership team received the same level of
No.
cooperation?
No,
of the prior?
absolutely not.
And if we had received that level of cooperation, would
Objection,
we?
Your Honor. Had we, if he wants to take the stand, he's welcome to.
I'm just asking a question, Your Honor. If the current leadership team had received that same level of cooperation, would we be here today?
Again, Your Honor, that calls speculation.
She's entitled to issue an opinion, Your
No,
Honor.
she is not entitled to an opinion, Your Honor. She's entitled to issue facts. And Mr.
She's-
Boykin was more than happy to take the stand.
She's well familiar with why we're here today, Your Honor. I withdraw the question. Thank you, Ms. McDaniel.
Thank you. Anything else?
I don't think so. I think you're good to go. Does anybody need her to stay, or do you want to stay?
No, Your Honor, I don't
No,
have her
Your
under
Honor.
subpoena, but I have no problem. I know
No,
she's
Your
had
Honor.
a tough week.
All right. Any other witnesses, Mr. Boyd?
Your Honor, we would call briefly, I think we've got enough information that the court can rule, but we would briefly call Roger Slagle to the stand.
Mr. Slagle. All right, there you are. And before you hit that seat, if you'll raise your right hand, please, sir, do you solemnly swear or affirm testimony about to give us the truth, the whole truth, nothing but the truth, so help you God?
Okay.
Just have a seat and answer any questions Mr. Boyd has on it, please, sir. Well, state your name. Well, he's going to ask it out.
Mr. Slagle, would you state your full name for the record, please?
Yes, Roger Slagle,
And what is your address, Mr. Slagle?
7739 North Ocean Boulevard, Myrtle Beach.
North Ocean Boulevard,
Yep.
Myrtle Beach. Is that your full-time residence?
Sorry?
Is that your full-time residence?
It's my address.
Is it your full-time residence?
Define what you mean by full-time residence.
You live there full-time?
Yes.
Question. I'm going to ask you to take a look at the list of properties that have been attached to the complaint. Are you familiar with any of the items on that list?
Some of them, yes.
Which ones are you familiar with?
Meeting tables, computer printer, financial records.
And so let's take them one at a time. Computer printer, are you familiar with that item?
Yes,
Do you know where that item is located?
I do.
Where is that item located?
It is in a storage facility
Where is that storage facility located?
in Myrtle Beach. It's Myrtle Beach Storage. I can't remember the name.
Do you know where in Myrtle Beach that facility is located?
Yes.
Where is that?
Can somebody help me with the address? It's a very large place that you can see from 17, where 17 and 22 come together. I think it's Myrtle Beach Storage and Conference Center.
Okay.
Strand.
Tables, same question. You familiar with those items?
Sorry, tables, yes. Folding chairs or stacking chairs, no. I think there were some chairs that were handed over that were literally needed disposal. We gave some of them away to a charity.
Let's talk about the tables. As to the tables, do you know where those are located?
Yes,
Where are they located?
in the same storage facility.
Same storage facility? Do you know approximately how many tables are located in that storage facility?
I think, if I recall, maybe 5 or 6.
What about, you said you were familiar with the corporate or the records? Did you say financial records, corporate records?
Yeah, I mean, bank account information, sure, financial records.
Where are those records located?
Combination of digital cloud space.
Do you have any paper records related to this market?
I've got a few, but I'm not a paper sort of person.
What paper records do you have?
We did a financial audit of the previous leadership and looking at proper documentation for expenditure of funds. So I actually do have some paper records of, let's say, 2017 to 2021 that was related to, in the matters that Mr. Von Herman was discussing earlier.
Okay. And where are those records maintained?
In a drawer.
In the drawer in what location?
In my house.
Same address you previously.
Yeah.
And the lawsuit that has been referenced that you filed, or that was filed on your behalf, related to pre-suit, authorizing pre-suit discovery related to, I believe, agreement for the, do you have any records related to that cause of that? Any correspondence from lawyers, papers, copies of pleadings, etc.?
Yes.
Where are those records maintained?
Digitally.
Do you have any other paper records that you can identify related to the party that you have discussed?
Yeah, there probably are some paper things, but again, I'm a digital person, so almost everything's digital.
To the extent you have other records related to the party, where would those be maintained? Would those also be maintained in your house?
Paper records?
Yes.
Yeah, probably, yeah.
So let me ask you this question, Mr. Schlegel. I take it from Mr. Von Herman's line of questioning that there's some objection to whether there was a quorum at the October meeting that's referenced in the pleading. Is that a fair statement?
That's correct.
To your knowledge, what was the required quorum for that meeting?
To my knowledge and what is written in the Horry County Republican Party bylaws is a 2/3 quorum.
And what's your understanding of what that 2/3 quorum would have been?
Sorry, what it would have been as far as number of people?
Yes.
Well, you take 2/3 of the organized precincts, and I don't remember the exact number, but I think it would be somewhere 50 some or more.
Okay. And at the October 11th meeting, when you suggest there was no quorum, did you object to the fact that there was no quorum?
Did I object? I was not present at the meeting.
Okay. Why were you not present?
Well, for starters, one of the positions that was attempted to be filled was a position that I was currently maintaining.
And did that excuse you from the meeting?
Actually, I wasn't even sent any notification for this meeting, for starters. But no, why would I go to a meeting where somebody's trying to elect somebody to my position, which I never vacated? It's sort of simple logic to me.
So have you raised the objection to the quorum at that meeting at any other time since the October meeting?
Have I raised it?
Yes. Have
Give me an example to raised it.
you ever raised the objection, for example, to Drew McKissick, that there was no quorum at that October meeting?
I don't believe I have. I don't think he would be the jurisdiction anyway. At the end of the day, the Horry County Executive Committee determines whether resignations are accepted, whether they're allowed to be rescinded, whether things were done properly. Anything going to the state would be for informational purposes only.
Are you familiar with the appeal of the state party and the county party?
I'm familiar with the state rules that clearly gives the accountability of the elections in a county party to that county executive committee.
What provisions of the rules do you refer to?
I mean, it says very, very clearly that if there's a vacancy, then the executive committee of that county has the authority and the accountability to fill it.
So, isn't that what happened?
I think what happened was you had a situation where people resigned. If you look at sort of the underlying things, and as well as you know quite well, bylaws, state rules are not going to cover every specific situation, but it is very, very clear in those state rules that says anything that's not covered here, one then relies upon parliamentary rules. And in parliamentary rules, it's very, very clear that in order for a resignation for it to take force, the accountable body, which in this case is the Horry County Executive Committee, actually has to take a vote to accept or reject that resignation, which never happened.
Are you aware of any instance in the past where the county executive committee of Horry County or any other county has voted to accept or reject the resignation of one of the
I'm not bringing examples. I'm stating what's in the bylaws and what's in parliamentary rules.
I'm going to show you Mr. Slagle, what we have attached as Exhibit D to our complaint. Would you take a look at that document?
Sure.
What is that document?
It's a letter that I wrote to the SCGOP.
And what was the purpose of that letter, Mr. Slagle?
To make sure that if things, let's say, as things move forward, to make sure that there was something that maybe I hadn't missed as far as any procedure for filling any vacancies.
Okay. And you quote some bylaws.
Mm-hmm.
What bylaw provisions do you quote to McKissick?
One about provisional chairman, one about 30 days to elect permanent chairman. In the case of a vacancy, the 2/3 quorum requirement, which we talked about, and then some of the state rules.
At any point in this letter, Mr. Slagle, at any point in this letter, did you tell Mr. McKissick that your resignation needs to be accepted or ratified by the county executive committee?
Sorry, I don't understand the question.
At any point in this letter to Mr. McKissick where you're trying to make sure that you've got all the bases covered, according to your testimony, do you advise Mr. McKissick or tell him in any way that the county executive committee has got to vote to accept your resignation?
I don't believe I put that in that letter, no. But again, I'm not talking about examples. I'm talking about what's written very clearly in black and white in the state rules and parliamentary rules.
When you stood up at the county executive committee meeting in September of 2022 and resigned, did you announce at that time that the county executive committee would need to accept your resignation?
I did not.
And you subsequently chaired a meeting of the Horry County GOP where you attempted to have a special election for other officers other than your own position.
That's correct.
Okay. What was the approximate date of that meeting?
September 26th.
And did you announce your unresignation at that meeting?
What I had done on September 12 was to resign with an effective date, and then on September 26, I basically withdrew that resignation.
So you announced at that meeting at that time that you would not be resigning and that the elections to be held at that meeting would be for the state executive committeeman and the vice chairman of the party.
That's correct. That's correct.
And what happened when you made that announcement?
Things devolved very quickly. A lot of acrimony, and a motion to adjourn was put forth, which was
I'm sorry. Go ahead.
a motion to adjourn came forth, seconded, and it was voted on, so we adjourned.
Okay.
There were a few other things that happened in between, but
And why do you think the executive committee voted to adjourn at that time?
I think you'd have to ask them.
I'll let you speculate.
No objection, Your Honor. We're not going to go into speculation, even if it's something like.
Was there a quorum at that meeting?
Yes.
No further questions.
And actually a two-thirds quorum, which I'll remind you is required by county bylaws.
Thank you, Mr. Slater.
All right. Mr. Herman?
Specifically, let's just talk about the election of the Mr. Boyd and the vice chairman and all those.
Right.
Tell us what, according to the bylaws and to the state law, what in fact it would take to replace, even if, let's just say that you had resigned and all the other, what would be the method and operation in which that position can be?
It's very clear that the county executive committee would hold an election with a two-thirds quorum requirement to elect new officials.
And who would have called that meeting?
The chairman of the party,
And who would that have been?
myself.
If there were such a reason to believe that you were not the chairman, that your resignation was effective, I understand you dispute that. What would then have been the backup?
The backup plan by the Horry County Republican Party bylaws is that you have a provisional chairman that was elected early on,
And who is that?
Michael Connett.
And Michael Connett, was he ultimately elected as well?
He was ultimately elected to the state EC position.
So, in other words, we have the person that declared that your resignation was permanent, that you were no longer, calling a meeting. Did he have the roll call, and did he, to your knowledge, or did he have and ensure that the bylaws and the state laws were in effect, and it's along of two-thirds of the present election?
No, he did not. And it's very clear. There is video evidence of this, but
So
yeah.
you got it.
Yeah.
Have you or others gone through a videotape and listed out the number of people present and the number of people that were not?
Yes, sir.
Do you remember, do you recall the number of people that it would have taken or that was allowed to vote under the EC?
At that time, there should have been somewhere around 80 or 81 organized precincts, which means that there should have been the availability of 80 or 81 ECs to be able to vote in this matter.
And a quorum would be 44, or excuse me, 54, correct?
A two-thirds quorum would be 54, yes.
And in your review, let me show you this document. Did you provide this to me?
I did.
And is that accurate to the best of the recollection as well as what the video has shown?
Yes, sir.
And can you tell the court how many folks were present from the executive committee?
I believe it was mid-40s, give or take.
About 44?
44, yeah.
What is the effect or the ability to hold elections if there are 44 and not 41?
It's basically, if you haven't met that two-thirds quorum, any result would be immaterial.
So there would be an election.
Exactly.
And what if and you haven't been the chairman, what if you were the chairman and you did not have quorum, would you have held that?
I mean, it's parliamentary procedure. If you do not have quorum, you cannot conduct any sort of business of that meeting. So anything that might be discussed is just discussion. So any sort of formal resolution, censure, determination to move in some direction with the party, it's all null and void because one didn't have quorum in order to have a vote on any sort of motion or.
Is there any rule that you're aware of that would have prohibited you, the treasurer and the secretary, to have revoked your resignation?
I'm not aware of any sort of rule or bylaw preventing that.
Who is, in your mind, today, the head of the Horry County GOP, and when does that turn into?
The chairman of the Horry County Republican Party is basically an executive committee. So you have ECs or whatever. I'm the elected chair of that executive committee.
And who would be the secretary and treasurer?
Secretary is Barb Tracy, who's sitting in the courtroom, one of the defendants, and no. So sorry, secretary, and then treasurer is Angela King, also sitting in the courtroom.
I know the court is, and we've gotten into politics now,
Sure.
and structure and things like that. I know it's not of great interest to anybody, but it is as far as who is the duly elected person, because that's ultimately who gets to claim it. Have you provided me this copy so I could understand exactly
Yes.
the relationship? Is
Yes.
that a pretty fair and accurate copy of how it's structured?
I think it is, yes.
Okay. Let me show this to the board and see if you disagree with anything. And I'm offering this just to help the judge kind of understand the relationship that I had to understand as well, and I'm sure he can cross-examine you as well.
Your Honor, this is just handwritten notes on a legal pad. I mean, it looks more like attorney work product than anything.
I think it's attorney work product.
It's-
It's my work product.
Your Honor, it's an opinion document at best.
And he's welcome to cross-examine him or ask his own witness. It's his witness. It's just, Your Honor, to help the court understand exactly what it is that the structure looks like in this. There's so many players, it's kind of hard to go by.
Your Honor, I would just reiterate that that's a document that's been handwritten by someone. It's not an official publication of any type. I don't know why Mr. Von Herman is waving his hands. I'm not even finished yet. And it's merely a scribble on a notepad is what it actually is. It's not a corporate record, to my knowledge, of any official body or organization.
And I take note of that, but I guess the prior officers were Secretary Barbara Tracy, right? Treasurer was Angela King. Chairman was at South Carolina GOP is Mr. McKissick. Chairman being Mr. Slagle. Shannon Grady is, okay, that's statewide. And I guess the vice chair would be Spurlock, right?
Yes, Your Honor.
That sound right of the prior officers? Mr. Boyd, I'm asking. Is that the prior?
That sounds correct, Your Honor, yes.
Okay. Well, for the sake of it, it is handwritten, and I'd
John, I'll offer it to you to the board, just
gotcha.
so you can have a picture. If it's incorrect in some way, I'm sure Mr. Boyd can square it away.
Yeah.
If it doesn't go to court, then I'm sure he'll just kind of part it off. In regards to this entire situation, have you attempted to work with and negotiate a resolution to come forward with a common front, even though each side is claiming to be the leadership?
We've had some initial discussions, yeah.
Did you have hopes that you could come about this and work it out in a way that would be good for the party?
I think whatever optimism I had, it maybe sort of doesn't exist anymore.
Right, but I mean, you went in.
Yes.
Yeah, that, I think Ms. McDaniel, in her testimony, she indicated there was, some talking, ugly calls back and forth. Well, that wasn't the committee and those are people exercising personal rights that are in the party. You can't complain, right?
Absolutely. Absolutely. No. No.
Are you aware of anybody in the executive committee that just hourly, bringing in that type of, senior officer, somebody that was within your recommendation, you didn't approach and say, this is not going to help us?
Well, yeah, I think, in fact, if we're bringing up names, Miss McDaniel is one of the people that very clearly, from an early stage, was conspiring to take out the elected leadership, to defame, to denigrate, to obstruct. So she was complaining about the ugly nature. I would maintain that she was there from a very early stage, trying to destabilize, trying to sow discord, and to obstruct, and from duly elected officers.
Anybody that you saw that was in support of your position or that you had any influence on, did you dissuade them from making comments that are personal in nature that hurt the party?
Yes, I try to get everybody to be as factual as possible, and but people, social media is the Wild West, and we do have a First Amendment, and I respect that First Amendment.
And in this regard, do you, as we sit here today, have you hired an attorney or been the liaison between the attorney and Columbia?
Yes, on behalf of the party, yes.
Give the court a little bit of the benefit of what that.
Sure. So it's a bit of a contentious issue that's existed over many years prior to, let's say, my involvement with the Horry County Republican Party, and it's over let's say documentation of expenditures.
I'm just going to object to this line of questioning. For the record, this action in Columbia has nothing to do whatsoever with the current claim and delivery that's before the court, just for whatever that may be worth. No, go ahead.
It does to this extent. He could not engage an attorney if he was not an elected official of the Horry County GOP when the caption of the case of the Horry County GOP versus Green Purdue or to the extent that he was exercising authority as the leadership, I believe it is wrong. Because the first thing, again, the court would have to determine is whether or not we have a split leadership here, or whether they have two people that are claiming to be leaders of this organization. And what evidence is there to show or support what they've done? And I think that retaining an attorney and bringing in action is something a leader of an organization would do.
Your Honor, with all due respect, no such determination or even an inquiry has been made. The only thing that's happened, to my knowledge, is that the party or that the former officers of the party have retained a lawyer in Columbia to bring an action on their behalf. There's been no hearing, nor, to my knowledge, any responsive pleading filed. So no court has even taken a look at this, Your Honor. The only thing that's happened is that the former leadership has walked into a law office in Columbia and hired a lawyer. And Your Honor well knows what due diligence a lawyer looking to collect a fee is going to do. He didn't do any due diligence. They represented themselves as the officers of the party, and the lawyer said, I'm hired. And that's it. That's the only thing that a lawyer in Columbia has done is prepare a file.
May I respond to that?
Y'all get paid for this? I understand. And I take it for what it is. It is what it is. Did he hire an attorney? Yes. Is it what capacity? I don't know.
Well, and listen, I think that's a great question. In what capacity did you hire the attorney, or did you approach the attorney?
Yeah, so we suspected, well, more than suspected, we knew that there wasn't proper financial documentation for a fairly large amount of money that basically belongs to the property. To the party. And so we did an audit, and we identified close to $26,000 where there's absolutely zero financial documentation. So that's when we then took some legal action.
Have you had an opportunity to ask or to review what it is the claim and delivery is for, the items that the plaintiff in that particular case is requesting of y'all?
Yes.
Unless you back to the structure, that property is actually, would be under the control and would be under the ownership of the South Carolina GOP, even though it's a subsidiary that controls it and is allowed to control it and have their own influence. Correct? But it would be the South Carolina GOP. That has the party name.
Yeah, I believe so.
I have no further questions.
Sure. Any
Nothing
other
further,
questions?
Your Honor.
Mr. Lake, you're free to sit down.
Thank you, Your Honor.
Yes, sir. All right.
Is that my list, Roger? No problem. Maybe that was you. Your Honor, no further witnesses.
All right. Any motions or whatever?
I just have one motion.
Sure.
And then if I could take just a brief 5-minute recess.
Sure.
To speak.
Certainly.
Your Honor, we would move, we believe that they have brought in the right party in interest, which is the South Carolina GOP represented by Natasha Hanna. That would be the party in interest for any type of claim where the court has ruled that would be allowed. I'm certainly not going to, at this point, dispute with the court at all. We appreciate the ruling. However, we would do a motion to strike as to the other three individuals that have brought this on behalf of the Louis County DOT in not the party of interest, in that their positions are challenged and that they would not have any type of information with regard to the ability to do a claim delivery. If a claim delivery was in effect offered or granted by the court, it would be on behalf of the South Carolina GOP and not on behalf of a subsidiary. And therefore, the court would not be called upon to rule in any shape or form whether Mr. Boyd and his group were the leadership or whether Mr. Slagle and his group were properly elected. However it is, the party in interest would be the South Carolina GOP, and they would ultimately have to follow the rule. And that way it would not put the court in the position where they have to make a finding of anything more than what we concede that the party in interest is, for the purposes of the claim and delivery, is the South Carolina GOP and not any individual on behalf of the Horry County GOP, period. And they would have the burden again, and therefore, with the substitution or the
Supplement.
the supplement that we, and again, we can resolve this today. I just don't think the proper parties to be aligned would be those three individuals. We move to strike them.
I know you.
Your Honor, just very briefly, those three individuals are the individuals who have possession of the property in question. Mr. Von Herman told you earlier today that nobody knows where this property is, and as a result, it's not proper for a claim and delivery. Well, we put Mr. Slagle on the stand, and he knows exactly where the property is and told us where it is. It's at the storage warehouse at the corner of 17 and 22. So now we know.
Your Honor, maybe I didn't make myself clear. I'm talking about striking Mr. Boyd and the plaintiffs. The parties in interest would be the South Carolina GOP, and it's certainly the defendants are properly named.
Well, and in that regard, Your Honor, Ms. Hanna, on behalf of the party, she's joined. If they objected to our bringing this action in our names, I'm happy, frankly, to step out as a plaintiff if the court finds it more feasible to consider this matter on behalf of the party, but I don't think that's necessary, and I certainly don't think that should delay the proceeding. I think if Mr. Von Herman wants to strike, add the state party as a plaintiff, and use that as an opportunity to further kick the can down the road, as the court says, I think that would be improper. I think the court has more than enough information before you right now. You've got an ample record for a claim and delivery, Your Honor, and I don't think we need to further complicate this any further.
Your Honor, one second. Can I speak to Mr. Boyd? This is sidebar. I'm not sure he understands it.
Certainly.
Are we going to resolve it today? Give me just 1 second. Yeah. 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 Yeah, Your Honor, I agree. We've been here quite a while, Your Honor. Mr. Von Herman is, well, I don't want to quote him, but Mr. Von Herman raises an interesting point, but I don't think there's any legal basis to strike us as plaintiffs. We do have an interest. I've been struggling with this job since I was elected in October. I don't think there's any particular reason that we need to be stricken as plaintiffs. The state party is here. They've been joined as a plaintiff. So and if there's some particular reason to strike us as plaintiffs, which I still haven't heard articulated, I just don't think it's necessary, Your Honor. All the parties are present. We're here. And I think Mr. Herman agrees with me that we should probably be able to get this thing resolved today. And I just think that's appropriate the way it's pled.
Yeah. Your Honor, just so I can be real clear to the court, our main contention is that the parties and interests are not the Horry County GOP leadership, the ones that's where the dispute lies. We have absolutely no dispute that the South Carolina GOP would be the party in interest as the only recognized political legal entity, and thus could maintain the status. We go back to square one and say that too should have brought this in. All we're saying is that it would alleviate the necessity of this court to make a finding that potentially could be adverse to any other court ruling or any other litigation may go on. It may not go on. Hopefully they'll all go to the common front or have an election. If the South Carolina GOP is stepped in, they're the real party in interest. So to move to strike the other three does not put this off in any manner. It doesn't change anything except for any claim and delivery if the court were inclined to give it or to provide it. And again, I would like a few minutes to talk to my client about maybe a possible resolution.
Do you want me to make that ruling now or wait for the break?
Well, Your Honor, let me just respond briefly before you decide whether you're going to rule today. I mean, the court, it's like a menu, Your Honor, and all the plaintiffs are on the menu. And if the court wants to issue a ruling that grants certain relief to some plaintiffs and not all, the court's certainly within its authority to do that. But I still haven't heard any legal, cognizable explanation for why the plaintiffs who brought this action need to be stricken at this time. I don't think he has one.
I know where we're going. We got two factions that I'm the chief. So am I going to make a determination who's what or what whatsoever? I think we're okay, but we'll take a break and we'll go from there. Unless you want me to make the ruling now, I can. I would certainly, I understand your motion, but I reserve the right, exactly what Mr. Boyd says. I can see a way to resolve it necessarily, because we got two factions that, you got too many chiefs and not enough Indians. And so it can be resolved, and I'm sure there will be an amendment to the bylaws that nobody expected this to happen, but it did. So I respectfully take that in consideration. I do grant that the South Carolina GOP is probably somebody that could take over, but they still have an interest just like they have an interest. So I reserve the right to make a decision which way or the other. Okay, without striking anybody.
Thank you.
And y'all want to take a break?
Just a 5-minute break, John.
Sure. We'll come back. On the 4:45? That's actually longer. No, that's 15 minutes. Well, 5 minutes. So 4:45, give or take.
I'm like, where can you get off pulling that stuff off? Oh, yeah. I mean, we kept going round and round on the same points. Now you see why I didn't want to move.
Yes. but you know what? It's
We're still here.
She was. I'm telling you, this way to make it into a. What did she think? This was going to be a. Are they paying you or are you paying? Yeah. It's on some grotesque level. It's interesting. Because Mike is not here, I was asking this question, but there are a couple of ladies in the audience who can the determination made by the parliamentarian about how we need to visit the majority. And I don't think he needs that. I think he's going to put it in favor. Yeah, absolutely. Absolutely. I'm fine with either one, but the first choice would be to turn it in. Yeah. 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 What's that? Peter Man. What's that? I've used Bert to mediate cases, but I've never gone against him. I don't know what to do. I'm going around in circles. Yeah. I mean, they were making our case at various points. And I hate to drag Judge Myers in this, but I mean, it's like, at some point, I know. His mom was Jack. Yeah, I'm not even sure if she's still that's the lady that was the she was real active in the theater. She was maybe still alive. She met last time I saw her was at a thing at Blue Light Auditorium several years ago. Dark hair, beautiful lady. Oh, it's totally. And I was thinking about clubs thinking about it. There are two really people inside of it that are just hell bent on destruction. It's like, you may not like Lindsey Graham, and I don't necessarily like Lindsey Graham, but to stand up there and turn your back when Donald Trump is there announcing his campaign for president, yeah, they were turning their back on him. I mean, it makes us look like Hicksville. Yeah, and it's like, y'all are doing a better job with the Democrats than the Democrats ever dreamed of doing themselves. And I'm like, how do you, it's like, I don't know. I talk to my wife. I'm just trying to salvage my marriage. Yeah. I'm just trying to salvage my marriage at this point. I don't care about the chairmanship. I just want to get out with my marriage. Yeah. Oh my God. There's clearly a wing, the liberal wing of the party that is, not happy all the time. And then you've got some ultra-conservatives, I think, who don't support it. You've got Nikki Haley, and then you like Nikki, she's got her own agenda. You've got Tim Scott, he's got his own agenda. Trump took a
what, didn't we, at the, yeah, something, he worded it in a weird way. You could tell who he was talking about, but it wasn't real clear. Yeah, you could tell he was taking a swat. Yeah.
All right, where are we?
Your Honor, I believe this quite possibly could work out, and we will be able to resolve it. I mean, depending on the motion to strike the non-interested parties, we certainly are in a better position to talk. And I believe there's no sense in obviously going through over today. I just think that they are not the parties in interest, or they wouldn't have been added in the GOP. And I think that at this point, that would be the best thing for everybody. And then let it, on one hand, they're asking, and we're asking you not to get into the political parties and all of that. The only way to do that, of course, is to eliminate the local Horry County GOP and allow it to go to the state to handle it.
Well, my understanding, Your Honor, is that you ruled on that motion before we went to the break, and you had denied that motion.
Yeah. Well, I certainly. Well, I sort of denied it, so I sort of didn't. I said I reserved the right to make a decision based upon the furtherance of the case. But I do agree that the GOP could take the reins, but what you're asking the court to do is to say who's the president at this time. Then I
apologize if I misled the court in any way about that. We're asking for the GOP to take because it's just a claim and delivery. So what our position is it alleviates the court's necessity to even remotely decide who the leadership is of the Horry County GOP. We will turn over the items to the South Carolina GOP, and they will, pursuant to their bylaws and all of that, they'll decide who it is that is going to run the Horry County GOP.
Is that something?
Your Honor, with all due respect, when we first started this process, they just said, well, just get us a letter from Drew, and that'll be sufficient. Well, you see in the attachments to the pleadings, there's like half a dozen letters from Drew. So that wasn't sufficient. So we're here. Now they're saying, oh, just make it about the SCGOP, and we'll turn it over to the SCGOP, and that'll take care of it. I think the case is properly structured. The plaintiffs are the plaintiffs. We brought this action not because we wanted to. We brought it as a last resort. And so now they're trying to say, let the SCGOP make the decision. It sounds an awful lot like what I heard initially, which is just give me a letter from Drew, and we'll abide by whatever that letter would say. Well, we've got half a dozen attached to our complaint. They didn't abide by any of them. And now they want to make Drew McKissick the plaintiff in all this. I think the parties before you are proper parties. As you said before we went to break, we have an interest in these proceedings just like they have an interest in these proceedings. And if the court decides for some reason, in the court's wisdom, that the relief needs to be granted in favor of the SCGOP, they are a party. That's within the court's prerogative, I would submit, but I don't think there's any basis to strike any of the plaintiffs at this point. But the court can decide how it wants to decide.
Just by way of clarification, Your Honor, I've never asked for a letter from Drew McKissick. I would have had him subpoenaed in today. I'm not sure where that comes from, but I don't doubt Mr. Boyd has been.
It comes from our personal experience leading up to this litigation.
I mean, you said it was requested of him. I didn't request it.
It was one of the requests that was made of me, not from Mr. Von Herman, but amongst the parties as we tried to resolve this matter informally, well before the claim and delivery was ever filed, Your Honor.
Well, I'm apt to go forward then. I guess we need to hear from the defense, and we'll go from there. But I don't want to cut my nose off to spite my face, I guess I'm trying to say. They did bring the case. We made a supplement to it, so I can't take it away. I can't supplement something and take away what I'm supplementing, if that makes any sense. I'd be overruling my own ruling.
Your Honor, the state would call Reese Boyd to the stand.
Come on up.
Or excuse me, the
state?
would call. Been saying the state too long, Your Honor.
Yes. Understandable. Mr. Boyd. And you're an officer of the court. I'm not going to make you swear. You are obviously know how it works. Go ahead. Any questions?
Mr. Boyd, can you please tell the board how the resignation of the officers of the Orange County Republican Party, how the bylaws and law require them to be there?
Well, that's an open question. My understanding is when you have a vacancy of all three offices, all the three executive offices, as we had in this case, then there is, at least in Horry County, there is something that we select at every convention that's known as the provisional chairman. That provisional chairman is directed to call a special meeting at which time new officers are elected to replace the officers who've resigned.
Okay, and tell me about who votes on to replace those officers.
That would be members of the executive committee.
And if the members of the executive committee, if I remember the stats, about 81, is that correct?
I don't know the exact number off the top of my head, but at various times it's fluctuated. Various people have been contacting us saying that they don't want to be involved or they're resigning. But so it's a reflecting, it's a moving target. But at some point that would have been an approximate number, yes.
So you would have had to have 54 people on the night you were elected?
I don't agree with that, no.
Okay. What would a quorum be? How many do you think you would have been?
There is a provision in the rules, Bert. I can't quote you chapter and verse, but first of all we had a parliamentarian at the office or at the meeting. Are you going to let me answer my question? Or?
No, sir. You answer my question. My question is, did you have to have a quorum in order for the election to be valid?
It is a meeting, like any other meeting. In order to transact business, you must have a quorum. Yes. And the quorum would be 53. Certainly 44 wouldn't be, correct? I don't agree with that statement, no. So you think 44 would be? If that is the math, yes. I mean, there's no magic number. Well, I mean, there is a magic number, 2/3 of the EC. No, I disagree. How do you disagree? Tell me what you're disagreeing with. I was just trying to answer that when you stopped me. There is a parliamentarian who was appointed for the meeting, Larry Richardson, thank y'all. Larry Richardson was the parliamentarian. There were individuals in this courtroom who were involved in the counting, the qualifying of electors for that meeting. They conferred, Bert, I had nothing to do with it. Mr. Richardson brought out a provision from the bylaws that said if that meeting takes place within 30 days, that the simple majority is the requirement for quorum at that meeting. And Mr. Richardson declared at that time that there was a quorum for the meeting on that basis. Again, if anybody who wanted to object to that had attended the meeting, had been there, they could have raised an objection, a timely objection under Robert's rules at that time. But the people, your clients who want to object to it now, were not there. They chose to ignore all those proceedings and raise these objections months later in a court of law, which is entirely inappropriate. So you're going to disagree with me that the parliamentarian, or are you going to say the parliamentarian overrules the rules of the Horry County GOP? No, I'm telling you that the parliamentarian present at the meeting, who was duly selected for the meeting, made a determination based on his review of the rules that we had a quorum. And so what if he's wrong? Well, if he had been wrong, if your folks had been there to object, they could have objected, but they weren't there, were they? Again, Mr. Boyd, I understand you're an attorney, but I asked the question. I know it's an occupational hazard. I know. We all get involved in it, I understand. But at the same time, please, and stick with me. No doubt that we both agree, take the parliamentarian out of it, that 2/3 would be a quorum. No, we don't agree. In this instance, I've just explained to you why that's not the case. Again, Mr. Boyd, you're saying with the parliamentarian group. The parliamentarian you're asking me to interpret the rules. I'm telling you that I had nothing to do with determination, by the way.
Look, let me give you these and tell me where it is that the rule is in the Republican Party. You're the chairman. You ought to know these things backwards and forwards. Tell me where it says that the parliamentarian can overrule the Orange County Board.
May I refer to my notes?
Sure. No, sir, that's the policy. I mean, that's what we got. That is, if you need glasses, I do have those, because I know that you're all getting a little bit older if you need reading glasses.
The provision that the parliamentarian relied upon, there is. No, I'm good. Let me get my glasses if you don't mind.
Listen, I never bad out of it. We don't get the phone or print.
Bert, again,
I mean, Ms. Boyd, if you don't know, you don't know. That's fine.
I don't recall the chapter and verse, but I can tell you from my experience, my recollection of the meeting is that Mr. Richardson, who was the parliamentarian for the meeting, conferring with others at the meeting who were involved in the establishment or declining to establish the presence of a quorum, made a determination that a quorum was present based on the provision that says, and I believe, I don't know if you've got the local rules in here, but there is a specific local rule that relates to that.
Sir, who makes the final determination?
Well, the final determination is the chairman's determination, but the chairman is generally going to rely on the determination of the parliamentarian on these issues.
And so if that's not properly recorded, you would know that, right?
If what is not properly recorded?
Well, I'll tell you what, watch this video for me and see if it helps your memory. Maybe it'll...
Unfortunately, we're getting a few other precincts that pass, just because you're saying that they're no longer organized. That's what we're counting that we've got, so we're trying to get the total on the executive committee members that we have right now. That's what we were basing this on. Yeah, we were basing this on 81.
I don't understand what...
There was another precinct where we know that one is no longer organized, so this would take us down to 79 if this is in fact something that I can address. How many do we have here right now? All right, so she's got 46 right now as far as what we have.
AJ got a total of 43. She got a total of 46. They were also counting unorganized precincts and adding other people in that weren't even on the list. Like Scott Kleinfelter's precinct. His president's here, but he didn't give proxy.
Who took this video?
But they said, whatever.
It's okay for sure.
You got a foundation for this video?
Again, you answer the question, I'll answer.
Your Honor, I'm going to object to this. This documentation or this video, I don't know if it's a video or an audio. I certainly haven't seen it. There's no foundation that's been properly laid. It's improper to admit this.
Your Honor, I learned less than 3 hours ago they were involved in this. I couldn't have given it to them.
She's been admitted as a party, Your Honor. She gets to object if she wants to object.
Who we got? Who is it?
And more importantly, Your Honor, it's completely irrelevant to the one issue that's before the court right now, which is claim and delivery of a half page of personal property.
Your Honor, again, it has to be the duly elected official that claims.
But, Your Honor, if they were claiming that we're not the duly elected officers of the party, they sent people in to record the meeting, but they didn't attend the meeting. They could have objected to all this, and it would have been timely, and it could have been discussed pursuant to Robert's Rules of Order if they had been there. But they chose to ignore the proceedings and send somebody in to record it and pipe it out to them so they could broadcast it on the Internet.
Your Honor, and this is a sticky situation, and I don't really like it, but there is a rule where an attorney that becomes a witness has to act like a witness while they're on the stand.
Oh.
And they cannot argue from the witness stand. What this amounts to is contradicting everything that they have put before the court, which is there is not a quorum, and nowhere in this does a parliamentarian or anyone else. And in fact, later on in the video, you will actually hear the provisional person go, we're just not going to deal with it.
He can play
Which
the
would
whole.
mean that the election is not a valid election, and they are not the duly elected official. I attempted to not have to go down this road.
Objection, Your Honor.
Which is exactly what I said. I've got to determine who's the chief and who's not. And that's what you want me to do, and that's what I'll have to do. But I mean, she gets to object to. I mean, it's no foundation. We don't know who took it and all that good stuff. I know it's the magistrate's court and we got lax, but we're dealing with at least 3 attorneys. So yeah, it comes back in to play. Now, granted, I'm not an attorney. I understand that, but I do know a little bit of the civil procedure. So we got what we got. So,
If I may just phrase this in the form of an answer to Mr. Von Herman's question, Your Honor, whatever that video says or doesn't say, there was a parliamentarian present.
Again, Your
The
Honor,
parliamentarian
witness
rule.
is not allowed
Objection, Your
to
Honor. If you
argue.
can allow the witness to answer the question.
There is no question.
Okay.
What I want him to do is watch the video, and then my next question is going to be, is this how you remember the meeting? If he doesn't
Your Honor.
remember the meeting this way,
Your Honor, I'm going to object to this again. I have not seen this video. This video has not been produced. If this secret video should not ever pop up in a court proceeding, if they had this video, it should have been produced a long time ago. This hearing's been scheduled for over 30 days. If they had this video, there's no room in this courtroom for surprise attacks, especially when we've never seen it. I don't know what's on it. It's not been provided to Mr. Boyd or to me.
yes,
there's surprise attacks like lawyers that show up at the court hearing and lawyers that, Judge, there is no discovery rule.
there's no discovery, but then again, there's rules of evidence that have to be presented. And of course, foundation has to be given of who took it and when they took it and all this fun
That's
stuff.
exactly right, Your Honor.
So I got to go with that. I just can't, I've got to grant her objection to it because we hadn't had any foundation whatsoever.
Do you disagree that this is a video of that particular night during the election, of those are people that you hear? Is that how the video went?
I don't disagree that it appears to be filmed in the location, but I can't testify whether it's an actual video of the proceedings, whether it's been edited, whether that, it sounds like you played a very small selection of a very long meeting.
Well, if we'd like to sit here for an hour and 11 minutes, I certainly will, if the court's inclined to do it.
You still haven't laid a foundation for it. I don't care to sit here for an hour.
Again, I appreciate your argument, but I mean, Your Honor, I'll do whatever the court wants to do. If you'd like, I'll be happy to put Mr. Slagle or Ms. Tracy up. We can do it. We can recall Mr. Boyd. However the court wants to do it. I was trying to do it simple.
I don't want to do it the long way.
If I may, Your Honor, neither one of those individuals were at the meeting. If they were there, they could test.
But
If
thank
it
you
matters,
again, Mr. Boyd, we are going to continue this until we're going to get out of hand. You are a witness, sir. You are not an attorney sitting there. You will answer the question.
Your
You
Honor.
will not ask the question.
Objection. One more time, if Mr. Von Herman can go ahead and identify who took this video and then lay the foundation and determine whether the person that actually took and recorded this particular video is actually in this courtroom today.
Yes, sir. The person that took this video was an intern for I'm Fired Up. It was reviewed immediately upon it. He was can't and had to leave because he had a radio show. He had planned on being here to play the video along with his wife. She had indicated and shown it to people immediately upon the showing. It had all the time, date, stamp, and it indicates everything that supports the testimony that's been given so far. There's absolutely no question that there's a foundation that it is. If you need to, you can go back to the hour and 11 minutes, and it'll be the call to we can certainly sit here for an hour and 11 minutes to hear the fact that there simply was no quorum present.
Your Honor, the proper foundation would be the person that actually took the video must come before this court on that stand, testify that they actually took that video, they were present. It's an actual full recording of what happened on that night. Based on what Mr. Von Herman just said, I do not believe that intern is here and present in this courtroom. So therefore, I would again object to any further testimony, review, or argument about this video. Second, Your Honor, I would go back to relevance. It is a waste of this court's time because this court doesn't have to determine the opinion as to whether this was a valid meeting or not a valid meeting to determine or to rule that the personal property should be returned to the Horry County Republican Party and or the state party. Thank you.
I think with regard to the Horry County, Horry County GOP, Your Honor, foundations can be made in a multitude of ways. It's not one such thing. If Mr. Boyd said that it appears to be the same place, the same meeting, that's sufficient. If he wants to go back and they can be a self-authenticating video.
Objection, Your Honor. That's not the law. That is not the rules of procedure. No, that is not how this works, Your Honor.
Here, the problem I got is she's not here to say, well, I took this part out. Or, I don't know if it's an hour, 2 hours. I bet the meeting lasted 3 hours. I don't know. Yeah, we'd have to sit here and listen to 3 hours of it if that was the case. But we don't have anybody to authenticate it. It's rules of
We have Ms. Tracy here who would send the video and
just sent the video. You have to have the person actually took it.
That took the video.
It's the rules of civil procedure. I got the rule on it, and I can't allow it. It is what it is. Now, granted, if we'd have done that while she was still here, or whoever it was, I don't even know. Then, granted, we'd at least have had some foundation, and you couldn't hardly object to that.
John, again, there is self-authenticating publications that occur all the time that are taken under judicial notice, and they give it whatever way the court or the prior fact may do. Everybody that takes the videos or any of that stuff are not always present. They take videos all the time.
Your argument is they didn't have a quorum. His argument is the parliamentary guy, Larry Richardson, said you don't need a quorum, you got a majority. I realize what we got. And so, for me to listen to it, for somebody else to say it, seems sort of moot.
There certainly doesn't have to be any authentication for cross-examination for purposes of questioning whether or not this occurred. There certainly is no evidentiary. I'm not offering this to the exhibit.
I'm assuming what the video will say is there wasn't a quorum, right?
Correct.
Okay. I realize that's what you're trying to do, or trying to purvey to the court. Of course, his testimony was there was a parliamentary guy there. I bet we don't have that recording of him there.
He would be on this video. It's a video of the entire meeting. We were just trying, Your Honor.
I don't know who was that talking. Was that the parliamentary guy? I don't know. As far as you can tell. Was that Mr. Richardson? Who was? I don't know who was talking.
I think the voices that you heard, Your Honor, it sounded like the people that were sitting holding the camera that were taking the video.
Huh.
There was an ongoing discussion, yes. They were very particular to not cut off any of the audio or any of the video, so it would be used at a later time that it would be available for people to view without a rating bullying until it would be off. I mean, it's really and again, it is cross-examination in terms of what he has purported to have said. Either, at the very least, Your Honor, he can watch it and he can say whether that's his recollection or not. If it refreshes his recollection and his testimony is different from what's on this video, that's fine too, Your Honor. You do not have to lay the foundation if it's for the purpose of refreshing his recollection. And he said 2 or 3 times, I don't know.
But they can't cross-examine the taker. They cannot cross-examine because they're not here.
That's great, but if he says, no, that's not right, I don't have any further, it's not evidence. It is to refresh his recollection. He indicates he's not sure, he doesn't remember. If this will refresh his recollection, it's certainly entitled to be shown to him, for him to listen to it, and if it refreshes his recollection, fine. If it doesn't, that's okay too.
It's,
Otherwise, the interest in justice is simply not served.
Mr. Von Herman, Judge, if I correct a misstatement of my testimony here on this stand, am I acting as a lawyer or a witness? I didn't say, my recollection is fresh. I recall what happened.
John, again,
I'm with you, but it's not.
John, this is not even hearsay. This is not offered for the truth of the matter asserted therein. It is asserted for the purposes of impeachment, which is not for the truth of the matter asserted therein. And therefore, it's not hearsay. Therefore, it's not got to be held anything.
So that's not evidence.
It is for the purposes of impeaching testimony for which he does not recollect. And he has stated no
Objection, Your
time
Honor.
that he does not recollect.
Objection, Your Honor. You have already ruled, Your Honor, that that video is not admissible. Mr. Boyd just testified that his memory is very fresh. He does remember. There's no purpose for the video, Your Honor. I would ask that you maintain your ruling that
I wish this would have happened, and I would put it this way. Before whoever took the video was here, we could at least laid foundation. I want to present some evidence of a video. We could have laid foundation, and they could have left and done what they wanted to do. And then we would either argued about it then or now, and I would have made a ruling on that. But now they're not here, and you're asking me to listen to something that has no foundation, or at least present it to the court as no foundation.
Thank you, Your Honor.
Are you disagreeing with the fact that it's not a quorum?
Yes.
Okay, how many people were present?
I don't recall the exact number off the top of my head.
So how do you know that the quorum was present?
Because we had multiple individuals, some of who are in the courtroom, responsible for counting people as they came in. We had a parliamentarian who was specifically in charge of determining whether a quorum was present or not. The parliamentarian consulted the rules, the local rules that specifically address this, which we were about to look at before you grabbed the video. And
Hold on one second.
can I finish?
didn't hearsay.
Do I get to answer the question?
No, it's not when it's hearsay.
I'm just telling you what happened.
No, my question was real simple. Was there a quorum?
Yes.
No further question. Oh, one more question. In your efforts, did you ever see or have you ever taken an opportunity to look at the roll?
Well, I've seen various roles over the course of my involvement.
The roll for that night.
Have I specifically reviewed the role for that night?
Correct.
This is October 12th, right?
Yes.
Okay.
I'm sure I looked at it at one point or another.
Do you have that with you?
No, I do not.
Okay. What would have occurred with that? Who would have kept that?
There were individuals, Bert, who were checking people in as they came in the door. The meeting took place at the HGTC auditorium. There was a table, sign-in table. As people came in the door, they would sign in, whether they were an EC or a president in the absence of the EC, or whether they had a specific proxy. Whatever the case may be, they would sign in, go into the meeting room, the auditorium, and there were various individuals, again, some of them here, who were responsible for that process. I had nothing to do with it.
Or can you familiar with this computer? Can you describe the computer for me?
My understanding, the computer,
The computer that you're asking for a claim and delivery.
the printer.
Or printer, excuse me, I'm sorry.
My understanding is that it is a Canon LaserJet printer that was purchased by Michael Conant. Mr. Conant couldn't be here today. He's not well. But my understanding is Mr. Conant purchased that printer for purposes of doing what what Jerry testified to earlier, what Jerry McDaniel testified to earlier, printing out ballots or forms for the reorg process.
Are you, when you provided to the court these various exhibits, I'm assuming this was to support your position in what you're requesting in the claim and delivery?
Are you referring to the exhibits to our complaint?
Yes.
Those exhibits were included. Burt to lay a foundation for the claims, explain to the court why we're here today and how we came to be involved in a claim and delivery between two sets of officers, both claiming to represent and manage the Horry County Republican Party.
And none of those are in affidavit form. None of those are sworn to. Is that correct?
Well, they're attached to a complaint that's filed by an officer of the court, Kelly Turek, in my office, who, by definition, attests to the validity of the claim when she filed it.
No, sir. And I understand. I would never ask. I take you at your word, and I'd certainly take your staff at her word. What I'm saying is, for instance, Drew McKissick under attachment H. That is not, his letter is not authenticated, and it's not sworn to or an affidavit form.
It is not an affidavit form. No, it is not.
And nobody's ever met with these people and sworn them in as we would do in our offices. We do it all the time to supporting documents, correct?
We do not have sworn affidavits.
Nope. No further questions, Your Honor.
If I may, Your Honor?
Sure.
Thank you, Your Honor. Mr. Boyd, are you current chair of the Horry County Republican Party?
Depends on who you ask, but yes.
And has the South Carolina Republican Party recognized you as the Horry County Republican Party chair?
Yes.
And at the meeting where you were elected as the Horry County Republican Party chair, was there also a vice chair, treasurer, and secretary elected?
We elected at that particular meeting a chairman, a vice chairman, and a state executive committee person.
And who was the vice chair that was named?
Rob Visconti. He was here earlier. He had to leave.
And who was the executive committee person that was elected that day?
Michael Conant.
Okay, and does the South Carolina State Republican Party recognize all three of those individuals as the duly elected officials?
Yes.
Now, under the bylaws of the Horry County...
And I would just add, they've done so numerous times, and at the most recent state executive committee meeting of the state executive committee of the Republican Party in Columbia, Mr. Slagle and another individual, also one of their officers, Shannon Grady, attempted to attend that meeting in Columbia, and the state party escorted them out of the meeting location under police guard.
Very good. Now, under the bylaws of the Horry County Republican Party, is that party, do they follow the South Carolina Republican Party rules and the South Carolina election laws?
Does the state party follow that?
Does the Horry County
Yes.
follow the state rules and the South Carolina election laws?
I would say the attempt is made to follow the rules, yes.
And regardless of your opinion or Mr. Slagle's opinion as to who the chair is of the Horry County Republican Party, it's clear the state party has recognized you as the chair.
Yes, that's correct.
And as the chair, has the state party directed you to obtain the personal property that belongs to the Horry County Republican Party and the South Carolina State Republican Party?
Yes, they have. As a matter of fact, in the attachments to the complaint, you will find a letter from myself to the former officers and also a letter from Drew McKissick to the former officers, both requesting the same thing, the return of the party's property to the current duly elected officers, who are the plaintiffs in this action.
And the list that's attached to the complaint, that's the list that we're asking this court to return, correct?
That is correct.
Okay, Your Honor, that's all the questions I have.
Your Honor, I have no more questions, but I would like to just address the court for 1 second.
Sure.
May I be excused, Your Honor?
Just as a matter of schedule.
None.
Your Honor, we do have present the individual that was sitting with the person that had videotaped that video. It was streamed live on Facebook Live. She had was present the entire time. She's indicated she's watched the video. It has not been altered or amended by any means, and she is willing to testify. My question to the court is at this late hour, and understanding we all don't want to kick the can down the curb, and I agree with you, I've got things myself. It is an hour and 11 minutes. She can authenticate it and play it for the court, and that way the court can see what took place at that meeting, and that basically that the meeting is invalid. And I think at this point, Your Honor, what I'm asking the court is how the court would like to proceed, whether they would like me to call the witness, which would put us probably close to the 7:30 hour by the time it's
Your Honor, this is yet another attempt to delay. This is a very simple matter. It's a claim and delivery matter for personal property. Your Honor's already ruled that this video is not admissible. Mr. Von Herman just indicated that the person that was sitting beside the person videoing the thing was here to testify. That's not an appropriate foundation. Your Honor has already indicated that you have an idea of what the video is going to show anyway. I would submit to this court that that is not an issue that's before the court at this time. You heard Mr. Lloyd just testify that the South Carolina State Party recognizes him as the chair. It is a fact that's been submitted in evidence. Therefore, Your Honor does not need to make a ruling on that issue because that's not an issue that's before the court. That is factual, that's already occurred at the state level, and Your Honor, that would only delay and drag this thing on out in an attempt to subvert the issues that are before the court. I would ask that Your Honor, again, deny that request.
Again, Your Honor, I was asking the court how you'd like to proceed. We're not interested in dragging it out. I can put her on the stand right now. We can go forward. What I was trying to do is, again, I'll leave it entirely up to the court. It certainly is proper foundation for her to have been sitting by, for her to have reviewed the video, for her to have known that the video was not cut off, and that it accurately depicts everything that she saw and it being recorded, and her discussions with the individual.
And we're talking about a meeting with 80-plus people being there?
Your Honor, there were supposed to be 80. There was only, I believe, when we counted it up after the roll call, there was 44, which was significantly less than the 2/3. What Mr. McKissick may or may not recognize in a part-time position in Columbia can only be recognized by the information that he has provided. And he's not here to be cross-examined. So it would be unfair not to go forward and allow them, with the proper foundations the court's required, to allow the court to hear the video, and hear what the parliamentarian said, if he said it from this figure, or hear what I understand it says, which is, we're not going to deal with that tonight. They've made a big deal about this objection, and somebody asked, what are we going to do about it? And Mr. Connick's response is, we're not going to deal with that tonight, and take it to vote. And then, of course, Mr. Connick also is ultimately elected to the position of influence.
Which contradicts what you just said. Somebody had to make an election. If they're not going to do it, they're not going to do it.
Mr. Connick said, we're not going to deal with the fact whether there's a quorum or not. We're going to do the election.
Right.
And then, ultimately, the election is held. Mr. Connick is one of the people elected.
And that's just audio? It's not video?
It's audio, video, yes, sir.
It's video too?
Yes, sir. And
I'm again going to object. You have already indicated that you understand what Mr. Von Herman's argument was. There was a quorum or there wasn't a quorum. You're the trier of fact, Your Honor. This video is not going to help you come to that conclusion any greater by watching an hour and 10-minute video. It's a waste of the court's time because Mr. Von Herman's already told you what it's going to stand for. You've embraced it. You said you understood it. It shouldn't have any bearing on your final decision because that's not an issue before the court.
Again, am I supposed to make a determination who's the chairman, who's the officers or not? I can do it if you want me to, if that's what you want me to rule on.
No, Your Honor.
If you want me to rule on that, then obviously I know the South Carolina GOP is a proper party.
And that's the reason I took the break and I extended it and made a motion to strike, but I think that would have been the appropriate way to have resolved this issue because, really the ultimate issue that they're trying to get to is they want this court to declare one side the winner or the other, and that's just not, if what they were really interested in then that would be one thing. But in order for them to get these items, the Horry County GOP, we will concede that whether it was them in possession of it or us in possession of it, that ultimately it becomes the South Carolina GOP that gets to determine the allocation of it, even, subject to other litigation possibly, but at the end of the day, they're the ones that get to decide as to property. But they can't violate the rules as they're told when they didn't attend, and then just tell me how I can present my defense to the case and not, because the court necessarily has to find that they are the party that is entitled. And what we've got right now is two parties, or two individuals, two groups, that both think they're entitled to it, including lawyers.
And to a fault, I might be wrong in how I rule. And that's what the great thing about appeals are. I might be wrong. But it's just sort of is what it is. Yes, sir.
Your Honor, just very briefly, if I can just interrupt one moment. Mr. Von Herman is now saying, well, let the state party decide, and we're okay with that. There is a letter among many attached to our complaint. It's dated October 24. It's from Drew McKissick, the state party chairman. It's directed to Mr. Slagle and Ms. Tracy, and it's Exhibit H to the complaint. Your Honor, it's a letter dated October 24. And in that letter, Mr. McKissick is saying, gather up these items and deliver them to the new officers of the party. And it just doesn't get any clearer than this, Your Honor. I don't think that the court can properly wade into the weeds on whether particular meetings were held in accordance with any particular standard. Your Honor, I just don't think that's appropriate at this time. If anybody objected, anybody in this room objected at the October meeting to the presence or absence of a quorum, they should have gone to the meeting and objected at that time. That was the appropriate time to register that objection. That objection is now waived. You can't raise that objection 6 months later in a court of law.
Your Honor.
And that would also force the court to get into the weeds of the party. This court, not only can it rely on the representation, I go back to the statement from the State Election Commission. Not only can this court rely on the statements of Drew McKissick and the state party as to who the officers, who's entitled to be custodians of the state party's property in Horry County, not only can this court rely on the statements of Drew McKissick, it must rely on the statements of Drew McKissick. It's as the statement from the State Election Commission states, that's the end of the inquiry, Your Honor.
Your Honor, because I want to be real clear about our position. Our position was, and remains, that we are trying to work this out and come at it with common sense. We are not saying, and I disagree with what Mr. Boyd is saying, that we all have to listen to Drew McKissick. Because the law, the South Carolina election law, requires that the 9 parties operate under the bylaws as established. We are not conceding that they're not entitled to it. What we are conceding is that these 2 parties can battle out who it is that is the leader of the GOP in litigation in a different court in a different setting. If their true concern is the fact that there's items that they're concerned about, if they'll give an accurate statement, not this affidavit of, stating the rightful property of Horry County at some time, then we're happy to work with Horry County South Carolina GOP. The issue is this court must necessarily find that who the party is. They have the burden of proof, and I will even be, as long as they're okay with it, I'll provide this court a copy of the video, and they're certainly welcome to watch it, and you can watch it at your leisure. I know I try to do that for judges all the time because everybody sits there and stares at the judge trying to read their facial expressions to see what they think. I'll do whatever it is to make it easier. I'm not trying to keep anything ready. These folks deserve a resolution as well. And these folks have all taken off of work. Everybody in this room has a very passionate belief in what they're doing. But we're also entitled to be heard as a defendant, and especially in view of the fact that we are going into this thing, we are actually determined to be the correct holders. They have to overcome the burden. We do not. We have to prove nothing.
Your Honor, we've been here since 2 o'clock. Everybody has had an opportunity to be heard today, and as Mr. Von Herman has observed numerous times, this hearing's been on the docket for 60 days. We've been here before. This isn't even the first time that we've been here, Your Honor.
Well, What on that video do you think that's going to sway the court to do one way or the other? If it's all about the quorum.
I believe that the quorum.
I don't think Mr. Boyd is going to testify to the court as an officer of the court. He's going to lie. I guarantee Mr. Richardson was in there somewhere. I bet he's on this video. He's probably not on that video whatsoever, as far as I know. I don't know. But if he's not.
No, sir, I do not think either one of these fine attorneys would ever misrepresent.
Okay.
That is not my point. My point is this was a long time ago. There is a lot of passion. People forget. People aren't paying attention. I don't think they're going to, but the most neutral position. And we see it all the time. I mean, we see it in law enforcement. We see it in everything else. The most accurate information that can be provided to the court is their opportunity to see the scene. I don't think Mr. Boyd on this hand and either one would misrepresent what occurred. But I do think the court had an opportunity, and I think we had the opportunity to present what actually occurred in sequential order. I certainly have been to a number of meetings. I can't remember an hour and a half of exactly what everything and everybody said. I believe that.
But you're asking the court to make a stretch. I was sitting beside the person that was taking it.
This person, Your Honor, will say that they had conversations.
Well, they'll say whatever they need to say.
She had reviewed it. It was accurate as to what she saw, that what occurred that night.
But can they testify that they go back and edit it or stuff like that? I know that's going to come up. You're asking the court. Now, the person that took it would be perfect.
Your Honor, may I interject?
Sure.
Let's make an assumption. Let's make an assumption that Larry Richardson said, I know we don't really have quorum, but let's just say we have quorum. He never said that. Nobody ever said that. But let's assume, for the sake of this statement, that it happened. There's an appeals process that's set forth in the rules. They had the right to appeal that decision immediately to the chair. That's Robert's Rules of Order. They could have said, no, you don't have quorum. And if they disagreed with the chair, they could have then filed an appeal. That's in the rules right in front of Mr. Herman. There's an appeals process set forth in the South Carolina Republican Party rules that allows you to appeal a process determined at the local level up to the state executive committee of the South Carolina Republican Party. That is the appeals process. If there was a meeting in October for which we were attempting to transact business, for which we claimed to have quorum, but for which we did not, that is the appeals process, Your Honor, and it's an exclusive remedy. They didn't participate in the process. They were able to find the meeting. They obviously knew the meeting was taking place because they sent somebody to record the meeting. But they chose not to participate, Your Honor. And that is their remedy. Their remedy was to participate and object and appeal any decision that they disagreed with pursuant to the rules of the South Carolina Republican Party. They can't come into this courtroom 6 months later and say, no, these guys really aren't the officers because they didn't have quorum back in October of 27. It doesn't work that way, Your Honor.
Your Honor, that still does not alleviate the necessity and the obligation of the party to do it the right way. It does not have, you cannot do something intentionally wrong and then get by with it because nobody appeals it, first of all. Second of all, everybody's not invited to this group. These are
everybody was invited.
Small. No, I didn't get an invitation.
Well, here, I have to agree. If you don't like my decision, you appeal me. If you don't appeal me, it goes through. If there's a provision in the election laws, whatever Section 7 is, you appeal it. And if they'd appealed the election and determined that whoever was the chairman through the state committee, we probably wouldn't be here. But now I realize why we're here is because the state has recognized them as the chair. Because there has been no appeal.
And Your Honor,
am I wrong?
I would ask where just he has not cited the section. I'm not doubting him. I just would like to know exactly where it is.
Okay.
Again, it says this is the exclusive remedy. It's not the exclusive remedy, and it's not the final determination, Your Honor. And, to a large extent, this court has acknowledged, and I think is correct, this is not a determination in and of itself. What I'm trying to do is give the court the opportunity to understand that there are questions with regards to the testimony we've heard today about, Ms. McDaniel took the stand and she unequivocally said there was a quarrel. Mr. Boyd, unequivocally, and I know both of them, and I know they would not intentionally misrepresent this court or any other court. But what I do know is minds are, they fade over time. They become involved in, I guarantee you Mr. Boyd and Ms. McDaniel had something to do the next afternoon or next morning. Things like that happen. But, Your Honor, again, the videographer is a couple of minutes. He's parking right now. If the court wants to hear from him, if the court would like, I'll make a copy of it. I just think it's relevant. I think it's important. I do think that whether or not it's appealed, we don't have to rely on Mr. McKissick for his ability to determine or to rule who the person is that is the county leader. In fact, specifically, that power is taken away from him in the bylaws and said is given to the county.
Okay. I really don't see why the court needs to see the video if y'all are disagreeing the entire time anyway. I know what the point is, what was said or what wasn't said, but the problem I got is the person's not here that actually took the video, and I don't know if they just went on one side or the other side. I don't know. I don't know if there was somebody talking in the very back of the room or the front of the room. I don't know. They might not have been on the video at all. So it is sort of is what it is. I can give you a rundown of this case pretty cut and dry. I know it's been a long case, but I don't think it's something that we need to sit for an hour and for me to already know what's going to be on it.
And, Your Honor, I respect the court's ruling.
Okay. I understand what you're trying to tell the court, but the problem I got with it, and I think if I sit there and watch the video, I'm still going to be posed with the same feeling about it, is that you've got one side video and their side, and the other side's not going to be represented, or it's totally correct. I don't know, and maybe that's why I should, but I already know what the argument's going to be, and they're still going to say that their testimony was their testimony, and yours is yours. So, all right. Anything else? I respectfully, with appeal.
Your Honor, we have nothing else.
Nothing else?
Nothing further, Your Honor.
All right. Closing arguments. I guess. Mr. Boyd.
Your Honor, again, I think the case is relatively simple. It is a claim in delivery. I think all the parties that are present before you are proper parties. I don't think there's any. The judge, Your Honor, has ruled on the motion to strike properly. There is a similar case that's transpired in Oconee County. That judge ruled. I think you are empowered to rule, Your Honor. I think for that personal property that's been testified to, that should properly be delivered to the current officers. The question becomes, who are the current officers? Your Honor, I think if you'll review all the materials in front of you, the answer is clear. The court, by definition, must rely on the representations of the state party to determine who the current officers of the party are. There is one party in South Carolina, and that one party is represented by Drew McKissick, who is the current chairman. And that party has spoken, and the party has said that the 3 plaintiffs in this action are the current officers of the Republican Party in Horry County. And as such, in that capacity, we're entitled to the personal property that's been described to you today. And we'd ask for an order stating that it be returned to us within a reasonable period of time. Thank you.
Yes, sir. Mr. Von Herman.
Your Honor, I believe Ms. Hannah might be.
Oh, Ms. Hannah, my bad.
Thank you, Your Honor.
Sure.
I would just echo the arguments of
Certainly.
Mr. Boyd. He said it very well. You've heard testimony from the stand that the South Carolina Republican Party has deemed, acknowledged, and recognized Mr. Boyd as the chairman. I would say that it's beyond the scope of what this court is required to do, and should return the personal property to the Horry County Republican Party and the South Carolina Republican Party. Thank you.
Thank you. Mr. Von Herman.
Your Honor, just briefly, and I know the court's been very indulgent in hearing our arguments. However, just want to point out to the court that the 1 to 9, again, these items, most of which they weren't even accurately described. Certainly, a computer printer was. However, again, we believe that they are not the party in interest, that at best, and again, we would dispute that if it wasn't for negotiations to try to settle it, because it is not vested in the South Carolina GOP. We're Horry County GOP is a subdivision operating under their own bylaws. The election was not handled properly. Clearly there was not a quorum. The vote was not accurate. Your Honor has been kind enough to listen to those arguments time and time again, and I appreciate that. But Your Honor, these issues are a lot bigger than just a claim and delivery. It's a Pyrrhic victory if they were to win, and it was quite frankly based on the inability for them to specify in their affidavit the materials that they were really seeking. Again, I think it exceeds the jurisdiction of the court. The court's ruled. I respect that. I object to it, but nonetheless, I respect the court's ruling. And as far as that, Your Honor, we trust the court that you'll do what's correct in your mind. We appreciate it, Your Honor.
All right. Here's, and I think I wrote it about halfway through. That's apparently it can be done from the leadership, or the officers can be elected, and it can be done easily, and because it's been done for umpteen years, I assume. So it can be done, and now, of course, we've got, just by the timeline, we've got the former officers, and they all resign on September 12th. With a date of when the rescind will be September 30th. The day you resign is the day you resign. I don't even know how that even makes sense. And then you try to come back, and there's nothing in the bylaws that says anything about how do you unrescind. And so we've got nobody running the show. The state GOP says we'll need to elect new officers. Was that election right or wrong? I don't make that determination. I guess it gets appealed to the executive committee in Columbia, which is probably the proper way it would have been done, and it probably still will be litigation based on that. But yes, the GOP ultimately owns the property, so I am ruling for the plaintiff. Now, the only problem I got is, and they recognize Mr. Boyd and the other ones as the new officers, and I think that's a foregone conclusion that most likely that might be the way it's going to work out. I don't know. They make that determination. So, and of course, we've got testimony about even the chairs, other than the printer. I think there was so many chairs that were there or weren't there. So many tables were there or weren't there. There are something in a storage room in Myrtle Beach, at Myrtle Beach Storage. And I think Mr. Slagle said he has certain items that he has on his computer, and some hard copies that needs to be given back. Everything else is kind of a tough road to hoe. It was able to be done umpteen times before. I don't know why it's being so hard now. Obviously, because the two parties aren't in agreements one way or the other. But as a Republican Party, you most likely need to be together as opposed to against each other. You've got enough problems, I guess, with the other political parties. It seems like you would be with one. And I think that's what the SC GOP in Columbia expects to happen. There shouldn't be bickering over something. Y'all should be able to work it out. But that's, I guess, what's been given to me to make sure that it happens at least at this level. So I am fining for the plaintiff. I'm not sure, Ms. Hannah, if you can. I don't know how I'm going to send the sheriff, I guess, to the Myrtle Beach storage, I guess to Mr. Slagle's house to get X, Y, and Z, or unless you can provide that to, I'm assuming, I'll leave you as the liaison, Ms. Hannah, because
Yes, sir. I'm happy to do that.
because there's some contention that it shouldn't maybe go to Mr. Boyd. I don't know. And then you can
That's
do with
fine,
it what you want. You know.
Absolutely.
And so anything and everything on this, like, granted, the ninth one is anything else. It pretty much is a catch-all. But the political memorabilia, I don't know if it's viable or not. It might be too old to transfer. The passwords, that might be something you have to recreate because somebody might not have it or claim they don't have it or whatever. You might have to start all that back over. And other records, I'm assuming the secretary, the treasurer would have that stuff. And so it should be given over, and I don't want to have to get into a thing where somebody's trying to withhold something because that you can be held in contempt of court. If that's the case, I don't expect that to happen, though. So with that said, I am finding for the plaintiff in this particular matter to hand over as much as you can on this list that you can, with the warning that if there's something that's held back, it can be held in contempt of court, and we don't want to go there. Okay? Anything else from either side?
Would you like us to prepare a proposed order, Your Honor?
Please.
Thank you.
All right.
Your
All right.
Honor, just for the say, I mean, can we have some time frame to get it together?
Oh, yeah, you
I don't know how long it'll take. I mean, I wouldn't think very long. And
You-
of course,
you-
they have to discuss.
you tell me, and we'll see if the plaintiffs have any objection.
Your Honor, if we could have 21 days, then they can make some decisions about any appellate issues with the other attorney or you know,
Sound
and discuss
okay?
it with me.
21 days?
Yes, Your Honor. That's
I'd
fine.
like the address of the, now some of this stuff should be easy to transfer. But we need to get that address of that, I guess it's Myrtle Beach storage somewhere in the midst of Myrtle Beach somewhere. I'm not familiar with that one, but we'll go from there, and if we have to come back with the attorneys to figure out what has or hadn't come, then we'll go from there. Okay?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Your Honor.
Thank you so much. Thank you. It was kind of fun. It's kind of like moot court, kind of like high school moot court. I've never been called to a witness before.
That was fun. I didn't expect it being 4 hours.
Don't tell me that. Thank you, sir. I won't say a word.
Thank you. Appreciate all your help. Thank you, brother.
Are they doing that?
Thank you, Bert. Yeah. Thank you. Appreciate it. What are you doing? You have nothing better to do today? You got wasted a little of all this?
I was getting out. You know, Ann's probably very short.
I drove all the way from International to see my grandparents.